parliamentarian from Austria who occupies leading positions in her Foreign Affairs Committee. Petra Beyer is the chairperson of the Committee on Equality and Non-Discrimination at the Parliamentary Assembly of the Council of Europe, where she also sits in the very influential Committee on the Election of Judges to the European Court of Human Rights, a very actual topic. Petra will speak today as board member of PGA, in charge of the International Law and Human Rights Program, which includes the Rome Statute of the International Criminal Court campaign. Petra Beyer, the floor is yours.
Thank you very much, Boris. Members of Parliament, honored guests and friends, which I can see on my screen, a very good afternoon from Vienna, from our Parliament. And I'm also delighted to welcome you to the 11th Consultative Assembly of Parliamentarians for the International Criminal Court and the Rule of Law, the so-called CAP-ICC. Since inspection in 2002, the Consultative Assembly has been the largest gathering, this year virtually only, of legislators supporting international and domestic justice for international crimes and the rule of law. PGA launched the first CAP-ICC in Ottawa, in Canada, at the end of 2002, the year in which the Rome Statute entered into force with the ratification of 66 states. Now, after 10 sessions of this Consultative Assembly organized by PGA and its national groups in New York, Wellington, Tokyo, Santo Domingo, Kampala, Rome, but also in Rabat, Dakar, and Kiev in 2018. We meanwhile have 123 state parties, and in 78 out of these 123 countries, PGA members played a leading role in the process towards ratification. On behalf of PGA, allow me to express my gratitude to our co-hosts, the PGA National Group in the Netherlands, led by Senator Boris Dietrich, and the donors and partners of PGA, including the European Commission, the Oak Foundation, the Swedish International Development Cooperation Agency, the governments of Denmark, the Netherlands, Switzerland, and Liechtenstein. PGA, the largest non-governmental multi-party international network of individual legislators with approximately 1,250 members in 136 parliaments, informs and mobilizes parliamentarians in all regions of the world to advocate for human rights and the rule of law, democracy, human security, inclusion, and gender equality. This global network of parliamentarians acting in their individual capacity is supported by a PGA national group structure in parliaments, which creates sustainability and ownership of issues at the national level, and by a secretariat with relevant expertise. PGA is in general consultative status with the Economic and Social Council of the United Nations with headquarters in New York. Its office in The Hague, Netherlands, fosters cooperation with The Hague-based international organizations, including, of course, the International Criminal Court. By using peer-to-peer methodology and country-specific strategies, the PGA Secretariat and leading members work together to educate, sensitize, build the technical capacity, and strengthen the political will of parliamentarians in order to take ownership, create initiatives and legislative action to achieve results on PGA's campaigns. PGA's parliamentary campaign for the effectiveness and universality of the Rome Statute and of the ICC system strives for the universalization of the statute and the effective operation of the ICC, as well as the exercise of national jurisdiction to fight impunity, and to seek justice for victims of the most serious international crimes. The Rome Statute of the ICC was adopted on 17th of July in 1998, after almost a decade of advocacy by BGA members since the UN General Assembly of 1989, when our former board member, Mr. A.N.R. Robinson, in his official capacity as Prime Minister of Trinidad and Tobago, tabled an innovative resolution that paved the way for restart of the process of establishment of the ICC, which had already been envisaged by the founders of the United Nations since the first General Assembly in 1946, but which was frozen by Cold War. The Rome Statute created the first permanent system of international and domestic justice for international crimes, in which states shall exercise primary jurisdiction on atrocity crimes, while the ICC must act as a complementary court of last resort when states are unwilling or unable to genuinely fight impunity. Given that the ICC may exercise its automatic jurisdiction only on the basis of the principles of territoriality and active personality, the ICC does not have universal jurisdiction, and it depends on the consent of the territorial state or the state of nationality of alleged perpetrators. Such consent is manifested for good when a state joins the statute. Therefore, only when the Rome Statute will have universal ratification and acceptance, the jurisdiction of the ICC combined with the one of the states will be truly universal. That means without any territorial loopholes and so effective. It must be stressed that the Rome Statute reaffirms all the general principles of law affirmed in Nuremberg in 1945 and 46, which the UN General Assembly validated as constituting part of customary international law in its first session in 1946 through a unanimously adopted resolution. Among such principles, we must hereby stress the importance of the irrelevance of official capacity of the perpetrator and the responsibility of commanders, military or political leaders. Therefore, if the ICC issues a valid arrest warrant, no immunity can bear investigation, prosecution, arrest, and adjudication of a sitting head of state, a parliamentarian, or any other official who would be normally protected by state immunity. Committing genocide, crimes against humanity, war crimes, or the crime of aggression cannot be condoned if it is an act of state, as we learned for the tragedies of the world wars of the past century, and as it was reaffirmed in June 2019 by an important judgment of the appeals chamber of the ICC regarding the case against Omar al-Bashir, who was president of Sudan when he was charged for crimes against humanity, war crimes, and genocide in 2008 and 2009 before the ICC, and who ceased to be the sitting president of Sudan in April 2019. Given that the Rome Statute is not a self-executing treaty and it depends on the efficient and effective cooperation by sovereign states, PGA actively engages parliamentarians and relevant stakeholders in the preparation, consideration, and adoption of implementing legislation to ensure the effectiveness of national jurisdiction in the collaborative relations with the ICC and in the application of the principle of complementarity. In addition, PGA participates in international efforts to increase support for the Rome system, for the Rome statute system and the court, in particular to secure better cooperation with states in enforcing outstanding ICC arrest warrants. PGA members have contributed directly to the decision-making and drafting process that led to the enactment of approximately 37 legislative packages on domestic implementation, including both the provisions on complementarity and cooperation with the ICC. PGA has also made significant contributions to the conclusion of ad hoc agreements with the court, the ratification of the agreement on privileges and immunities of the court. We as parliamentarians have the duty to play a critical role for the universality and effectiveness of the Rome statute system, as well as for building and strengthening the rule of law, enhancing victims' access to justice, truth, and reparation. We must always remember the promise we made after the Second World War. Never again. Never again to genocide, crimes against humanity, war crimes, and the crime of aggression with impunity. We have an individual and collective commitment as legislators in our respective states and as citizens of the PGA family to make sure that the promise made at the Nuremberg is honored, also in memory of the millions of victims murdered by the Nazi regime and its murderous system. This is also the best way for us to celebrate tomorrow, 20th of November, the 75th anniversary of the opening of the Nuremberg trial, which started on 20th November 1945 in the aftermath of World War II. This will be our contribution to fulfilling PGA's vision, namely to contribute to the creation of a rules-based international order for a more equitable, safe, and democratic world. Thank you very much for your attention, and I wish us all a very productive and fruitful meeting. Over to Boris again.
Thank you so much, Petra. Actually, in the program, we had a little bit of time for questions and answers, but on the other hand, I am very mindful of the time and of the fact that Judge Ogon Kwon is calling in from South Korea. It's late in the evening there. So I propose that we will continue with the President of the Assembly of State Parties, Judge Ogon Kwon, for his keynote remarks on the topic of the Rome Statute of the ICC. The floor is yours, Justice.
Thank you, Mr. Dietrich. Your Excellencies, distinguished delegates, ladies and gentlemen, good morning, good afternoon, good evening. It is my great pleasure to speak to you today. I would like to thank the organizers and the sponsors for convening this important event. It is great to meet you again, esteemed members of the PGA and the staff of the Secretariat, after we met in Kiev 2 years ago. 2020 has been a particularly challenging year. The COVID-19 pandemic has shown that the global threats we face today cannot be solved in isolation. Yet, international cooperation is ever more demanding and at times uncertain. The global fight against impunity is not immune to these challenges. The system of international justice is essential to promote peaceful, just, and inclusive societies. In times like these, we must avoid losing confidence in our judicial institutions, and we must continue to work collectively to protect them and to improve them. In this regard, the universality of the Rome Statute of the ICC is a very important goal, and one to which I have given particular attention in my time as the president of the ASP, now coming to a close at the end of this 19th Assembly. While the ICC is a relatively recent addition to the emerging trend of international courts and tribunals, it already plays a primary role at the forefront of the global fight against impunity. The ICC has made significant achievements in the fight against crimes that affect humanity as a whole, such as the use of child soldiers, sexual violence during conflicts, attacks to civilian populations, and the destruction of cultural property. Today, the court has active cases in all stages of proceedings. All its jurisdictional triggering mechanisms have been activated. As a result, the ICC now has a fairly large body of jurisprudence on a range of fundamental international criminal law issues. The ICC is playing its part in contributing to the global effort to prevent genocide, crimes against humanity, war crimes, and since recently, the crime of aggression. By ratifying or acceding to the Rome Statute, a state sends a strong signal to the rest of the world in support of the international rules-based system where all states have a voice. This, in turn, reinforces the notion that no individual is above the law. Ratification is also an expression of solidarity with all victims of crimes committed around the world. Moreover, ratification of the Rome Statute is an investment for peace and stable societies with an increased access to justice, which can contribute to the prevention and deterrence of future crimes and increased economic developments. In other words, by joining the court, a state not only invests in the protection of its territory and its people, but also in future generations and in the creation of a more just world. Ratification should not be interpreted as a concession of sovereignty. The ICC investigates and prosecutes cases only when states are unwilling or unable to do so genuinely. One of the cornerstones of the Rome Statute system is that it recognized the primary jurisdiction of states to investigate and prosecute atrocity crimes. In this sense, the ICC is a court of last resort. It is intended to complement, not to replace, national jurisdictions. This humble, yet powerful proposition is one of the main strengths of the Rome Statute system, that together, state parties, in cooperation with the court, we can and will continue to fight against impunity. But the court remains bound by its treaty limitations and therefore is unable to address all of the mass international crimes that continue to be committed in the world. The ICC has a global mandate, but it has not yet achieved universal participation, as Petra pointed out a minute ago. This is why achieving universality is such a crucial objective, essential for the legitimacy and effectiveness of the court. In spite of the challenges we are facing, there was some good news on the universality front this year. I would like to take this occasion to congratulate once again Kiribati for becoming the 123rd state party on the 1st of February this year. It is my sincere hope that new accessions such as this will help to further build the support for and understanding of the court in the Asia-Pacific region and beyond. Distinguished guests, ladies and gentlemen, the court navigates in a complex international environment and faces a numerous challenges, some external, some internal. Externally, the court challenges range from a harmful and unfair perception of selective justice to limited cooperation from the UN Security Council and direct attacks from major powers. Internally, the court has been criticized for lack of clarity in the legal standards applied to its criminal proceedings, inefficiency, and ambiguity in its prosecutorial strategies and policies. It was in recognition of these challenges that the Assembly of States Parties adopted last December the resolution on the review of the International Criminal Court and the Rome Statute system. The proposal for an independent expert review of the ICC system immediately resonated with states parties, the court, and civil society in light of their shared common goal to ensure good governance, accountability, and the effectiveness of the court in the global fight against impunity. This process is the most far-reaching exercise the Assembly has commissioned since the court began its operation in 2002. A group of 9 independent experts, headed by Mr. Richard Goldstone, who is present here, was mandated to make recommendations to the ASP and the court on specific complex technical issues under the clusters governance, judiciary, and investigation and prosecutions, while strictly respecting the judicial and prosecutorial independence and the mandate of the court. The group of experts issued its final report at the end of September. I should emphasize that the findings in the report were focused on areas in need of improvement rather than an exhaustive overview of all the aspects which currently work very well within the court and the Rome Statute system. The Assembly will now certainly consider the experts' recommendation and will take decision on how to move those recommendations forward. All stakeholders must do their part for this project to succeed. In particular, state parties and the court need to share a common language for this process. But state parties among themselves also need a common vision for the review process to come to life. And they need to provide the court with genuine political engagement and increased diplomatic support. To do this, there must be a genuine reflection on the role and structure of the Assembly of States Parties as well. My hope is that carrying out this process in a transparent and inclusive manner will strengthen the trust, resilience, and solidarity among state parties and the court, and I'm doing everything in my power to go in that direction. Something that certainly will have a significant impact upon the court sooner rather than later is the election in December of 6 new judges and a new chief prosecutor. As you know, the latter is an extremely unique position. As the head of the OTP, this person is the face of the court, responsible for identifying situations, undertaking investigations, and selecting and prosecuting cases. The state parties adopted some innovations for the process of this election with the establishment of the Committee of the Election of the Prosecutor, or CEP, assisted by a panel of independent experts. After receiving applications and interviewing candidates, the CEP submitted its final report in June, containing an unranked shortlist of 4 candidates for the position of the prosecutor. Public hearings were then organized for the shortlisted candidate with state parties and civil society. Together with the help of the two vice presidents, I led consultation with state parties to seek to identify a consensus candidate. Unfortunately, however, after serious attempts, state parties did not yet manage to reach consensus around one of the 4 shortlisted candidates. The Bureau recently decided that the best way forward is to broaden the consultations to include additional candidates interviewed by the CEP. This will give us the best chance of reaching consensus, building on the valuable work of the committee. While there have been some challenges in this process, we must remain optimistic. This is the only 3rd time we are choosing a prosecutor since the court's inception, and the process is rather unique in the world of international organizations. We must also learn from this experience in order to strengthen it for future elections. From my side, I will continue to endeavor to guide the consultations in a way that ensures we elect the best candidate by consensus at our 19th session. Ladies and gentlemen, delivering international criminal justice swiftly, fairly, and with quality is not a job the court can do on its own. The court is encouraged by the strong support and cooperation of over 120 states parties, but also by the support from other states and international organizations, as well as civil society, including the important work carried out by organizations like Parliamentarians for Global Action, for which I am truly grateful. We must continue to stand firm to protect and promote the principles and values enshrined in the Rome Statute and help the court realize its true potential. Thank you for your kind attention.
Thank you so much, Mr. Kwon, for your wonderful words. Very, very inspiring. You told us you have to go to another meeting, and I think this also counts for Paul van den IJssel, the Dutch ambassador. So before you would leave us, maybe it's a good idea to ask Mr. van den IJssel, to give a few remarks, and then we will have a group picture taken, and then we let you go. Is that okay with you?
Yeah, thank you. I have actually to go to the same meeting online as Judge Kwon.
I know.
Being nevertheless 1,000 kilometers apart. But thank you very much, Senator Dietrich and President of the Senate and all those listening, and especially representatives of Parliamentarians for Global Action. It is, of course, a pleasure to address you at this 11th Consultative Assembly of Parliamentarians on the ICC and the rule of law, co-organized by the Global PGA Network and the PGA Dutch National Group. As was said by the President of the Senate already, the Netherlands is proud to be the host state and a firm supporter of the International Criminal Court. Accountability and the fight against impunity is one of the top priorities of Dutch foreign policy. It is crucial for victims to know that in the end, the perpetrators of the most serious crimes will be held to account and that justice will prevail. The ICC is a court established by states. Unfortunately, not all states are willing to join our fight against impunity yet. And universal adherence to the Rome Statute remains our ultimate goal, as has been said by previous speakers. As co-focal point for universality, we are encouraging states to join the Rome Statute system and provide information about what this means for states. And at this point, I would like to express my gratitude and appreciation for the role PGA has played in this regard. At the same time, states parties need to adopt effective national legislation to implement the Rome Statute and to reinforce their national capacities. And there is a clear role for you as parliamentarians in this regard. After all, the role of the ICC is to complement, not to replace, existing national judicial systems. It is crucial that the ICC is able to work independently and free of any interference. Unfortunately, however, accountability and international criminal law are under severe pressure and face political resistance at the moment. We cannot allow non-state parties to block the quest for accountability for the worst international crimes, which the court pursues. The Netherlands finds the sanction imposed by the US against the prosecutor and the director within the office of the prosecutor deeply disturbing. And we are disappointed that the US took this step after we and the broader international community repeatedly called on them not to do so. And you may have read in an op-ed I published today, the Minister Blok published today, together with his colleague from Belgium and Luxembourg. He called upon the incoming administration in the US to, as one of their first acts, to withdraw the executive order against the ICC. The Netherlands, as host state of the ICC, has in response to the imposed sanctions taken several steps the last couple of months to ensure that the ICC will be able to continue its work. We will continue to defend the independence of the ICC and to support it in its fight against impunity. Since accountability and the fight against impunity are of key importance to the Netherlands, we have to make sure that the ICC is doing the best it can. Therefore, we attach great importance to our common efforts aimed at reviewing the function of the court to make it stronger and more effective. We have welcomed the recent report by the independent experts review. The court and state parties must now follow up on the recommendations and implement reforms with a view to strengthening the Rome Statute system, as well as the efficiency and governance of the court and its working climate. We also look forward to welcoming a new prosecutor and 6 new judges this upcoming Assembly of States parties. And we would like to underline the importance of electing the candidates based on individual performance, quality and merits, and not as the outcome of political horse trading. In order to strengthen the court, we also need to look more critically at our cooperation as states with the court. States parties need to support and facilitate the work of the court throughout the various stages of its judicial proceedings. This includes the prompt execution of outstanding arrest warrants in line with states' obligation under the Rome Statute. And we are glad that the court arrested 2 suspects this year. However, more needs to be done. And in this context, let me say that we very much welcome the signals of increasing readiness of Sudan to cooperate with the ICC. In addition, voluntary cooperation by states is vital for the efficient functioning of the court. A practical way to support the court in this respect is through the conclusion of framework agreements regarding witness relocation, release of persons, and the enforcement of sentences. I hope that all states will support the measures needed to strengthen this important institution. And I also hope that the present reform exercise serves as an additional incentive for states who have not done so to join us in Rome and ratify the Rome Statute. It is very important that parliamentarians work together to achieve justice for victims. It is our collective responsibility to ensure that the court can carry out its mandate, despite the challenges it faces. I thank you very much, and I wish you a very fruitful assembly. Thank you.
Thank you so much, Ambassador van den IJssel. I turn back to Mr. Kwon and I ask you, Mr. Kwon, do we still have time for a few questions and answers? Maybe you should unmute yourself. In the meantime, we should get ready for the group picture. I don't think we have to do anything but smile, right? That was what they told me. So let's smile, and thank you so much for both your contributions. Is there some time for questions and answers, Mr. Kwon?
I'm fine.
Yes, perfect. Then if somebody has a question, please raise your hand in the raise hand button below. And then I can give you the floor. David, I do not see everybody. Do you see if there are any questions for Mr. Kwon or Mr. van den IJssel?
so far, I cannot see anyone raising the hand. It means the ambassador and the president of the assembly have been so clear in their job for the next. It seems in the next meeting they may take very important decisions for the months to come on the next prosecutor, judges, and so forth. So I think we. But there was one question that was sent from one participant, and this is a question that many of our members have posed in the past, especially from the African continent. And the question is, and of course we have with us also the Office of the Prosecutor, and we will have hearings tomorrow with them, is why the court cases as of now only regarded individuals from the African continent. How can we explain this? And there are different ways, of course, to explain it, but maybe I think it's worthwhile to immediately address this question that came already in writing from two participants from Zimbabwe, for example.
Yeah. Thank you so much. Justice Kwon, please respond.
Well, did I unmute myself? Do you hear me?
No, yes.
Yeah, that is appearance of selective justice is a unfortunate result of what's happening, but it's based on some kind of misconception. Not all the cases are triggered by the court, initiated by the court itself. Most of the cases were referred to by the state parties themselves or the United Nations Security Council. So also there are many cases the OTP is looking into. So I would say it's not a correct understanding of what's happening. I hope that answers the question briefly.
Thank you so much. I would like to note that we have members of Parliament on this call in this webinar, but also members of NGOs, non-governmental organizations. And I see on my screen Richard Dicker, working for Human Rights Watch. And because I worked for Human Rights Watch, I would like to put him on the spot and ask Richard Dicker if he has a question for Justice Kwon.
Scary.
Well, thank you, Boris, for putting me on the spot. I'm not sure I can fully rise to the occasion, but I value the opportunity to put a question to Judge Kwon, whose hard work and tireless effort over nearly 3 years has been so valuable. Judge Kwon, could you say a bit more, and I appreciated your remarks a moment ago, about how you see the independent expert review report strengthening the court and enabling it to function on a firmer and more solid basis. And I ask you that, sir, given your experience at the International Criminal Tribunal for the former Yugoslavia, as well as president of the ICC, Assembly of States Parties. Thank you very much.
Well, as we are working hard on that, I would I would limit myself to so I will reserve my answers to the later stage. We'll come back with some concrete results. We are working on some resolutions in terms of what we are going to do with the recommendations by the committee or the experts. So that's all I can say at the moment. I hope you understand the situation.
Thank you so much for this. David, I see that you raised your hand.
Yes,
And
yes.
maybe you can say also something about this group picture.
Oh, yes. Okay, let's do the picture before the president goes.
Exactly.
So I would like to ask our colleagues to activate their camera, like Honorable Dorcas Simbanda is here, and any other who can put up their camera. We will try to have a quick shot, maybe Daniel and Tiago or Brian, you can take care of that. Let's proceed.
And in the meantime, we are smiling, right?
Yes, okay. 1, 2, 3, and that's it. I think it's done. And
it's done already.
Yeah. I think so. I wanted to ask one thing to the president before he goes, and of course also to Ambassador van den Issel. I think the president highlighted the delicacy of the moment, because essentially you are meeting now and in the following weeks to select the new prosecutor, identify an assembly that could be viable. We have this COVID-19 crisis that impedes the usual types of meetings. So my question is, do you think you will be able to finish everything by the end of 2020? Are you optimistic?
Well, so I'll work very hard.
Okay,
I'll do my best.
I would like to hear a perspective from Ambassador van den Issel too.
We'll do our best.
Okay.
I mean, in the end, it's the result that counts. We should have the best possible prosecutor at the court. And I hope we'll find one soon enough. Thank you.
Thank you, Ambassador. And we deeply appreciate in PGA, and I think Richard can join me in this on behalf of the other NGOs, the level of access and cooperation we have been receiving, not only from the ASP, but also from the regional bloc to which Ambassador van den Issel is part of the European Union. And I know that there are representatives of the European External Action Service following us today. So we really hope that with the joint work of all, including all the other regions of the world, of course, there will be an agreement on the third prosecutor after Mr. Moreno Campo and Ms. Bensouda. Thank you. And there is maybe one final question that was posed, and I don't know if the ambassador wants to take on it, the president wants to take on it, or we leave it to the next session. One of our members asked, what is the legal and how are the legal and jurisdictional matter of the ICC developed? This comes from a member of parliament of Nepal. In other words, who is the legislator within the system of the ICC? Who decides on eventually, I don't know, amending the Rome Statute or other legislative and jurisdictional matters that pertain to the system?
I'm not sure I understood the question.
I think the question refers to the role of the states as legislators. So, given that in domestic system, it's parliaments that decide on the legislative and regulatory frameworks, I think the question was meant to be directed to you as chair of the ASP. Of course, you are a judge too, but in this capacity, you have a new role to play.
At the ICC, the Assembly of State Parties, or the ASP, plays a monitoring role of the court as a whole. So it has the legislative power to amend the Rome Statute, which is the founding treaty of the ICC. When I worked at the International Tribunal for the former Yugoslavia, their judges had the power to amend the rules of procedure and evidence. But here at the ICC, it is for the Assembly of State Parties to amend the rules. So there's some controversy in order to improve the efficiency or in that regard, but it is for the ASP. And so in that sense, as ASP has much greater the responsibility as compared to the other ad hoc tribunals.
Thank you so much. I see there's a short question for Ambassador van den Issel. and it will be put by Stephen Rapp.
Well, thank you very much. And I know you're late for a meeting, but I want to thank Ambassador Van den Eyssel and certainly the Ministry of Foreign Affairs in the Netherlands and Belgium and Luxembourg for this statement on the ICC today and its communication, together with other issues, to the incoming Biden administration. But as we in the US, we're discussing other ways to ensure that this executive order and these designations are withdrawn on day one. We were considering the importance of having finance ministries in Europe as well engage with the US, particularly because using the sanctions in this particular way, this really outrageous way to go after people that are enforcing the law, will undermine the effectiveness of sanctions that the EU or the US or others need to take outside the framework of the UN because of vetoes in the Security Council against major human rights perpetrators, Magnitsky type sanctions, et cetera. And we'll lose the effectiveness of this tool if it's abused in this way. And I'd urge you, obviously, appreciate the forward-leaning position of the foreign ministries who obviously deal with these relations. But I think it would be a very important message to get finance ministries to convey that to the US. So we've got additional pressure within the Biden transition to ensure that this goes away right at the beginning and isn't something that drags out with continued negative effect.
Thank you so much. Ambassador Paul van den Eyssel, do you like to respond?
Yeah, thank you. I'll be very brief. I listened, as always, with great interest to Ambassador Rapp. For the Netherlands, the Ministry of Finance is very much involved in this discussion. For other European countries, I can't vouch, but this is dealt with also at the level of EU. So I'm sure finance ministries are aware of what is happening. I hear your call upon finance ministers to be active across the ocean. I thank you for that. Again, I will keep it in mind and I'll convey it to others in the ministry. But thank you very much.
Thanks so much. I see there is another question from the Member of Parliament, Gonise from Zimbabwe.
Yes, thank you very much. Firstly, good afternoon, distinguished participants, honorable members. I would like to express my gratitude and appreciation for the keynote address that was given. My question really relates to the desire to have the universality of the Rome Statute to be applicable throughout the world. And at the moment, most countries which are not party to the Rome Statute, like Zimbabwe, for instance, which is a signatory, but which has not ratified.
Thank you so much. I think that Mr. Kwan has left us. I don't see him on my screen anymore. He already announced he had to go to this other meeting.
And it gives an excuse to those other countries which are guilty of these transactions not to ratify the Rome Statute, and also to claim that this is targeted at African leaders, bearing in mind that the majority of the people who have been prosecuted have been from the African continent. And I don't know whether, in terms of our dialogue, in terms of our engagement, whether there's any likelihood of any progress in getting some of these big powers on board, so that they can also be part of and parcel of the Rome Statute, which would then enable those other countries which are given excuse to have no excuse for not ratifying the treaty.
Thank you so much for this. If Ambassador Paul van den Eyssel cannot really respond to this question, we will note it and we will come back to it in the course of these 2 days that we have this webinar. But maybe Mr. van den Eyssel, do you would like to respond? I don't see the ambassador on my screen, so I presume that he also left for the other meeting, which we knew. So I'm too late in thanking the distinguished guests for their contribution to our webinar, but we will convey these thanks later on. It's now in the Netherlands 5 minutes past 3. we already have been taking this group picture, so I think we can move on to the next part of the program. And that will be a discussion with three distinguished guests: Petra Beyer, whom we've heard before, Justice Richard Goldstone from South Africa, and Ambassador Christian Vannaweser, permanent representative of Liechtenstein to the United Nations. Can I give the floor to Petra Beyer for the first remarks in this session? Please go ahead.
Thank you very much, Boris, again. Yeah, the focus of this session now is on challenges for the international criminal justice in general. And we will start with some insights into the Independent Experts Review Report. The acronym is IER, which also suggests, among a lot of other issues, new ways how to elect judges and how to choose the new prosecutor. So while not all findings and recommendations of this report appear of equal importance and relevance in terms of their potential to offer practical and workable solutions to problems affecting the International Criminal Court and the Rome Statute system, the report provides a unique tool to make changes and reforms to the court and the Rome Statute system 80 years after the entry into force of the statute and 22 years after its adoption. The ICR report's recommendations are directed to all the organs of the court, to the assembly of state parties to the Rome Statute, and to state parties as well, to concerned observers, for instance, non-governmental organizations, legal practitioners, academics, analysts, social scientists, including criminologists, journalists, and also members of parliament as well. In some cases, all these actors and observers must take relevant concerted action. Otherwise, reforms and improvement of practices by one set of actors may be blocked or undermined by the conduct of the other. PGA, as I already mentioned, is an international NGO that aims to creating, feeding, and supporting a global parliamentary constituency for the Rome Statute system. Parliamentarians, of course, can play an essential role in inspiring, instigating, and defining governmental politics and policies, also in respect of international organizations and in exercising oversight and scrutiny on implementation of such policies, as well as in explaining to their electorate the purpose and practice of international organizations and the necessity of domestic measures to make sure that these organizations can fulfill their mandate. Therefore, parliamentarians can play a pivotal role in advocating and generating support within state parties and their assembly established under the Rome Statute to ensure that these entities make their essential part in the process of implementations of the report's recommendations, while supporting internal processes within the independent juridical organs of the ICC to do the same within the self-contained treaty-based system of the ICC. So excuse me if I get a little bit technical now. And I also want to put a spotlight on the really most important and immediately workable IER report recommendations for change. It is totally impossible to mention them all. The paper that you report has more than 350 pages, and I'm sure you would not like to listen to all the recommendations now. So let me just summarize some. there is the demand to improve the working culture within the ICC. There is also the demand to improve the capacity and productivity by internal reforms. And by the way, of course, also more resources and more budget is needed. There is also the wish to improve the coherence and consistency and the productivity of the Office of the Prosecutor, which plays a crucial role in the whole system. And hand in hand with that, also to improve public communication, for instance, with a spokesperson or a senior media advisor, as it is really important that also the general public understands and realizes the importance of the court and what's going on there and why decisions are taken as best they are. Beside that, it is important to improve the effectiveness of the Office of the Prosecutor and the ICC as a whole. There are several recommendations that the Office of the Prosecutor needs adequate resources to be able to conduct investigations and also to be able to open new cases. There are ideas how the leadership, but in particular the prosecutor, should establish a regular consultation with the heads of the UN agencies which are relevant in this respect. And the Office of the Prosecutor should also establish a focal point for maintaining bilateral relation with civil society organizations at its headquarters to really have an outreach and a connection, a stronger connection to civil society. There is also the idea that the Assembly of the State Parties and the State Parties themselves should develop a strategy for responding to attacks on the court, mostly by non-state parties. And there is also a proposal for the reform of the national system of nomination of judges. Because it's important we need to improve the process for this election to guarantee that persons are elected or selected that not only bring the necessary competences, but also personal inviolability for this job. And that also would ask for the harmonization of the national procedure for nomination, and also to have a clear base where public calls for application should be published. And I think for those who are more interested in the topic of how or maybe what the ICC system could maybe learn, knowing that there are two very different systems, of course, two very different courts. But we will organize an exchange in early December, what from these experiences we made with the European Court of Human Rights, where every member country, 47 member countries, have one judge. This is different, of course. And the Council of Europe has a parliamentary assembly. And we have a committee in this parliamentary assembly who receives suggestions with 3 names of 3 potential candidates, which we screen. When the requirements are fulfilled, then we invite them for hearings. We make number 1 to 3, we make our preparations, and then the whole assembly votes the judges. And knowing that it's not possible to transfer simply that system to the ICC, I think it could give us some ideas how we might better develop and put it on a broader base, the selection and election of the court, of the International Criminal Court. So, but to have the possibility to talk now with experts on this issue, I'm very happy, first of all, to announce Justice Goldstone, which is an outstanding expert regarding the ICC. Justice Richard Goldstone is one of the most prominent international jurists and he was the first South African appointed to a senior international position after the end of the apartheid era, upon indication and encouragement of President Nelson Mandela. Richard Goldstone was appointed by the UN Security Council as the first prosecutor of the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda, 94, so after 94 and 95. And he is now a retired justice of the Constitutional Court of South Africa. His name is very often associated with some of the most important reports and initiatives on human rights and the rule of law of the last 30 years. And Justice Goldstone, we are very happy to have you with us. And may I ask you to take the floor and provide some inputs and insights.
Well, thank you very much indeed to Parliamentarians for Global Action for this exciting invitation to join this important meeting today. It's worth repeating that 2021 will truly be a crucial year for the International Criminal Court. President Kwan's already referred to the fact that there will be a new prosecutor, 6 new judges, a new president of the Assembly of States Parties, a new president of the International Criminal Court, and a fairly recently appointed registrar. And there will also, of course, be the consideration by the organs of the court and by the ASP of the recommendations of the IER. The IER, as you know, was established against the background of many criticisms of the performance and governance of the ICC. Those criticisms came from many quarters, including former presidents of the Assembly of States Parties. The criticisms came from governments and from civil society. The 9 members of the IER were appointed by the ASP from most regions of the world. They brought with them practical experience as judges, prosecutors, and wide experience in governance. We worked in 3 clusters under our mandate, 3 clusters or 3 groups concentrating respectively on governance, the judiciary, and investigations and prosecutions. The report, which was published on the 30th of September, contains the findings and recommendations of each of those clusters. As has been mentioned, the report is a voluminous document. It contains the findings that introduce and explain 384 recommendations contained in the report. Those recommendations cover all of the issues that were referred to the IER by the Assembly of States Parties. Those issues excluded, broadly speaking, issues that were being investigated by other working groups that were established by the ASP. Our report contains in an annex the prioritized recommendations, those that the IER considered to be the most pressing and the most urgent for implementation. A brief reference to the index of the report will indicate the breadth and depth of the issues that were considered. Consultations were held by the IER with current and former officials, staff and external defense and victims representatives, heads of court organs, the Staff Union Council of the ICC, state parties, ASP representatives and bodies, NGOs and academics. Hundreds of consultations were supplemented by over 130 written submissions. The members of the IER are hopeful that the report and its recommendations will receive detailed consideration by the ASP and by each of the organs of the ICC. We certainly, I should mention, received the fullest cooperation from those organs and from the Presidency and the Secretariat of the ASP. In the introduction to the report, we suggested that the ASP should establish a standing coordination or working group to follow up on the consideration and implementation of recommendations made in the IER report. Such a coordination or working group should report regularly and transparently to the Assembly of States Parties on its progress. It is important that such a group or committee should be representative of all organs of the court and the ASP. The members of the IER decided at their final meeting in September that their members would not comment in public on their findings or recommendations. It was thought that was a good way to avoid confusion with regard to what is contained in the report. The report, after all, should speak for itself. Being bound by that decision, I hope that you will allow me to use my remaining few minutes to raise an issue that was not included in the mandate of the IER, and that is the use of the veto power by the permanent 5 members of the Security Council to prevent egregious war crimes being referred to the ICC. This issue really has been raised obliquely in some of the discussion and questions during our first session today. For some years, and even more so today, there are criticisms of the ICC to the effect that the crimes being investigated and prosecuted by it relate to war crimes that are eclipsed in their magnitude, in their horror and their gravity by those committed in countries that are not before the ICC. The issue of African countries and non-African countries is indirectly related to this consideration. But too many people, I would suggest, including some politicians and journalists, appear to be unaware that the ICC's jurisdiction, as was mentioned by President Kwan today, is limited not only by complementarity, but also limited to crimes committed in or by nationals of states that have ratified the Rome Statute. One reads frequently that it is unfair that the crimes committed in wars in Africa in particular are being investigated and prosecuted by the ICC, but not the horrendous violations that have been and still are being committed in a situation such as Syria. And what about the egregious crimes being perpetrated in Somalia or Yemen, or as we speak, most probably in Ethiopia? The problem, of course, is that Syria, Somalia, and Yemen are not states parties to the Rome Statute. And the nations that are conducting surrogate wars in some of those countries are also not states parties. There's unfortunately simply no jurisdiction. It is through no fault of the prosecutor that the crimes are not before the ICC. Of course, this makes it an unfair system. But surely I would suggest some justice is preferable to no justice. The imbalance that is there in the international humanitarian situation, that imbalance cannot mean that there should be no less or no support for the ICC. The only way the ICC might achieve jurisdiction over the atrocity crimes being committed in those countries would be pursuant to a referral by the Security Council, acting under the provisions of Chapter 7 of the Charter and Article 13b of the Rome Statute. There can be no doubt, for example, that the situation in Syria has and still constitutes a threat to international peace and security. The Security Council thus has competence to refer the situation to the ICC. There's been no shortage of attempts to have the Security Council make such a referral. Those efforts by members of the Council have failed only because of the exercise or threatened exercise of the veto by Russia and or China. In fact, we have recently seen a series of 16 dispiriting vetoes by Russia, some joined by China, blocking various resolutions related to Syria, including a referral to the ICC. Powerful nations are not prepared to have crimes allegedly committed by them being investigated by an international court. This opposition is also exemplified by the inappropriate and misconceived sanctions imposed on the ICC by the outgoing United States administration in the face of an investigation into crimes allegedly committed by the United States, by United States nationals in Afghanistan. Professor Jennifer Trahan of New York University has launched a project aimed at preventing the use or threatened use of the veto that is directed at blocking a resolution aimed at preventing the commission of atrocity crimes such as genocide, crimes against humanity, and war crimes, or the punishment of persons who might be guilty of committing such crimes. Professor Trahan has recently published an important book that sets out the relevant history and law relating to such use and threatened use of the veto power by the permanent 5 members of the Security Council. The title of the book is Legal Limits to Security Council Veto Power in the Face of Atrocity Crimes. The short proposition on which her project is founded is that there are legal limits to the use of the veto in the face of such atrocity crimes. The legal argument is that the veto power is conferred by the Charter of the United Nations, and its exercise is subsidiary to Jus Cogens norms. Those are norms that are recognized by international law as binding on all states and from which no derogation is permitted. Such norms are clearly binding on all members of the Security Council, including its 5 permanent members. Under Article 24 of the UN Charter, in discharging its duties, the Security Council, I quote, shall act in accordance with the purposes and principles of the United Nations. I would suggest that a veto or threatened veto in the face of a draft resolution responding to genocide, crimes against humanity and war crimes does not accord with the Charter's purposes and principles. Furthermore, the permanent members of the Security Council are bound by treaty obligations such as the Genocide Convention and the Geneva Conventions. I might add that apart from the actual exercise of the veto, there's an equally pernicious use of the threat of its exercise. That threat appears to have the result that resolutions under threat of veto are simply not placed before the Security Council. Let me conclude by stating that one of the goals of Professor Trahan's project is to form a group of states to join an initiative to have the General Assembly recognize the aforementioned legal precepts in a resolution. The General Assembly should recognize this limit on the use of the veto. And it suggested too that the General Assembly might request an advisory opinion from the International Court of Justice along the following lines. Does existing international law contain limitations on the use of the veto power by permanent members of the Security Council in situations where there is ongoing genocide, crimes against humanity, and war crimes? I would encourage members of all parliaments around the world who support international justice to pressure their governments to support this initiative. If states become aware that they will likely not be protected by the use of the veto power, in at least some situations, that might act as a powerful deterrent. At the very least, it would enable the International Criminal Court to become seized of all atrocity crimes that are not appropriately investigated and or prosecuted by the states that have domestic jurisdiction over those crimes. It is a project that deserves your support. I thank you.
I thank you very much, Justice Goldstone, on the one hand for your insights in the work as chair of the Independent Expert Review Panel, and on the other hand also for putting our debate in a bigger multilateral context, also mentioning Jennifer Trahan, who closely collaborates with us as PGA as well. And I have the pleasure now to hand over to Christian Benavesa. Christian is not only the permanent representative of Liechtenstein to the United Nations in New York, he is also the long-standing and uniquely effective chairperson of the UN Advisory Group of Parliamentarians for Global Action. Beside that, I think the masterpiece of Christian's career has been his tenure as president of the Assembly of State Parties and chairmanship of the Kampala Review Conference for the Rome Statute that introduced the definition and the conditions for the exercise of the ICC jurisdiction on the crime of aggression. And Christian, on the other hand, will comment on the input of Justice Goldstone, and then also after his comment, moderate the question and answer session. Christian, the die Bühne gehört dir.
Vielen Dank, Petra. Thank you, Petra. It's great to be here always with PGA. My big thanks to David and his team, to Margaret Sederfeld, and it's a really good moment to have this conversation. PGA and the individuals gathered in PGA have played such an important role to make the Rome Statute a success story. And I think more than anyone, we owe it to them to have a conversation with them where we are now with respect, in particular, to the IER exercise that we are talking about here today. I want to put this a bit in a larger context. The first thing in my view, to look at is the overall international framework within which we are moving. The Rome Statute was adopted in '98. One of the highlights of the '90s, which was probably the peak of multilateral activity, and now in 22 years later, in 2020, we certainly find ourselves in a period of crisis of multilateralism that we have not seen since. So this is not limited to the ICC at all. We have seen, talks, controversial conversations about WHO, about UNRWA, about UNESCO, about the UN itself. So multilateralism and the rule of law, as such, are being challenged and questioned in a way that we have not seen before. So it is only natural that the ICC, which has a mandate that is bound to make some people unhappy. The ICC does have the jurisdiction to hold those criminally responsible who bear the biggest share of responsibility for committing the most serious crimes under international law. By definition, these people are powerful people, and those who do not believe in the rule of law and those who do not believe that the law should apply to themselves are naturally having a problem with this institution. So it's clear that this is a difficult time for an institution like the ICC in particular. I think there's no need to go into that in any more detail. Speakers before me have talked about this, in particular about the unprecedented sanction measures, or measures, I should say, taken by the US administration. Ambassador Rapp has talked about it. We have heard from our colleagues from the Netherlands, Belgium, and Luxembourg. We certainly, join the call for the executive order in place to be revoked. But that is the overall, framework within which we are moving. So a difficult time for multilateralism, a very challenging time for the rule of law, and as a result, attacks on the International Criminal Court. There is a second dimension to this, and that is less talked about. I think there is also a difficulty in the understanding between the court and the state parties, the 123 state parties that make up the Rome Statute system. This is sometimes overshadowed a little bit by the very blatant and flagrant external attacks that are carried out publicly. But I think the reality is that we have been having a difficult climate between the state parties and the court. And this is where we think the IER is the opportunity we must grasp to put ourselves on a better track. So what we hope to see and what we expect to see in a way from the IER is that we regenerate a common sense of purpose. I think that must be the result of this exercise. There is a common sense of purpose, sometimes lost in our perception, internally within the court. So we would like to see a dynamic that is much stronger and more positive within the different branches of the ICC, but the common purpose in particular between us from the state party side and the court side. Very often now we are talking at each other and not with each other. The court is of the view that it does not get sufficient support from us. Many of us are of the view that the court does not sufficiently deliver. I think we are both right. We both have a point, but the point is to find an agreement and a common way forward, and the IER is our opportunity to do this. Richard has mentioned it. I myself and some of my colleagues that have served as presidents of the Assembly before have made our views on this public and have asked for an exercise such as the IER that has now thankfully taken place. And I really want to take this opportunity to thank Richard and his team for the work that they have done with a very high level of commitment and of professionalism, and that they have offered us an extremely rich menu to choose from. So as a result, we are hoping to see, as I said, a rebirth of a sense of common purpose, which is expressed in particular in two ways, I believe, namely unequivocal political support expressed by states if and when the court needs that, including in intergovernmental bodies such as the Security Council that Richard Goldstone has talked about, but also in many other areas and in other platforms. And the other is that we have a common understanding of the financing of the ICC, namely that the ICC can always count on a solid financial basis, and that we do spend much less time also talking about money, and that we talk more about policy questions and mainstreaming the ICC into the wider international conversation. So that is how we look at the exercise. So where we stand now, in our view, is we have a great basis, thanks to Richard and his team. And in December, we will hopefully agree on the parameters how to move this forward. For us, a couple of things are key in this respect. One is certainly, as President Kwon has said earlier in this event, that we have a process that is inclusive, that is transparent, that includes, first of all, certainly all state parties, which is not a given because, for example, in The Hague, we're not all present. In New York, we are. We want to have inclusion of civil society because civil society has been a key actor ever since the effort to create the Rome Statute system started, and we want to have a joint platform to discuss these things with the court. We want to have the input from the court, and we want to be able to give our input to the court. We also want to do this on a basis of a very clear understanding of what our responsibility is, what the court's responsibility is, and what our joint responsibility is, because we do have our areas of competences. And there's certainly some governance issues that are for state parties to decide. If we are to talk about amendments to the Rome Statute, which we do not believe is very urgent because it's a very, very good treaty, but that would also fall within the competence of the exclusive competence of state parties. But there are also areas that fall in the exclusive competence of the court itself, because again, as President Kwon has said, we must safeguard and respect the judicial and the prosecutorial independence of the court in this exercise. The timing could not be, I think, better in this respect, because we are looking at this very big breaking point and new chapter in the history of the ICC. We will have new leadership in OTP. We will have 6 new judges. We will have a new president of the assembly. And we want to have these conversations also with the people, for example, that present themselves as candidates to head OTP for the next 9 years. We think it's extremely important to hear from them what their vision is, how their vision is compatible or not with what the IER has given us, and then to move forward together. So the main areas for us are management issues, governance issues, consistency in the jurisprudence of the ICC, and communication challenges. Petra has talked a bit about the contents of the IER, but I wanted to give a bit more of a political message here, and how I see the way forward, and how we will work for this as a committed state parties together with our like-minded colleagues. So that brings my comments to an end. I understand we do have now 20 minutes for a Q&A, and that questions, I believe, are asked in the chat function, so the floor is open for this. I have agreed to moderate, obviously, this part, so please feel free to raise any questions and thoughts that you have with respect to the 3 presentations you have just heard. The floor is open.
Christian, while everyone takes the movement towards taking the floor, I just wanted to say something that really links the presentation of Justice Goldstone with the everyday work of PGA. Justice Goldstone highlighted how, unfortunately, the Security Council has been selective in allowing the court jurisdiction only on 2 situations, Darfur, Sudan, and Libya, and not in other situations. I think Ambassador Stephen Rapp, who is with us today, and many others from state parties, including you, Christian, worked relentlessly to get Syria in 2014 to the jurisdiction of the court, as Syria was the worst theater of mass atrocities in the world certainly until 3 years ago. But in that case, Russia vetoed the resolution. And that brings us to the main goal of PGA, which since the beginning has been to have as many parliaments and governments to ratify the Rome Statute, so that we don't depend from the Security Council, which is based on certain power politics that have been established after World War II, whether we like them or not. And you, Liechtenstein, your government, Christian, and many others are the leaders in an effort on transparency, accountability, and more democracy that is aimed at limiting certain features of this power, especially in this framework of mass atrocities. We have done a lot of work here. But let's say our main goal is reaffirmed by the presentation of Judge Goldstone. Another issue that I wanted to bring to your attention, which was raised by Petra, is the election of the judges. So in addition to the prosecutor, of course, these Assembly of State Parties will elect 6 new judges. And we have the example of some countries that have done a very good job in publicizing the call and allowing the entire society to know, here is a position that one of our best women or men can occupy. And for example, in Uruguay, the entire parliament unanimously endorsed the proposal of Dr. Ariela Peralta as a judge for the ICC, and the advisory committee on nomination has assessed her as fully qualified for the job. This was the implementation of a law of a PJ member who sadly is not with us today because he sadly departed in April, Felipe Michelini, who will be commemorated by our president at the end of today's session, who had the very idea to create this consultative assembly back in 2002. But Uruguay, in this example, is only one of those in which we can also take note of which countries did a good job in selecting in a democratic way, in a transparent way, the best possible candidates, while other countries, they made a political appointment. There was a foreign minister who picked up a certain individual and said, here we are. We want this gentle person to represent our country in the framework of the ICC. I think after this meeting, one of our action points could be to disseminate knowledge on this process. So when the election takes place, everybody knows what their government will do. And most of you represent states that have a vote in that assembly. Christian, when will that vote should take place in New York?
The vote on the judges? Oh, well, you should have the ASP leadership here. We are hoping as soon as possible because, of course, you know, we're nervous about the public health situation in the city. I think what the leadership has so far said is on the 17th of December. We're hoping actually for something a bit earlier, but we also do believe that you know, these elections could take place even if there was to be a lockdown again in New York City, because we did have successful elections for the Security Council in the month of June when the UN building was not open and the city was in lockdown. But you know, since you gave the floor back to me, David, maybe I can say a word on the issue of Security Council that Richard also touched upon, and you did so as well. Now, in addition to the point that you made, namely, you know, the incredible importance of working towards universality, and that is what you and your team and PGA has been so very good and effective at, and we should not lose sight of that goal. Of course, the ratification process has stalled in recent years, and that has slowed down, but we did have another ratification. President Kwon talked about it, Kiribati did join, and you know, the political circumstances in countries do change, and we do have to look for these openings and for these opportunities. The change in let's say attitude vis-a-vis the ICC and Sudan was mentioned in this call. This can happen in other places, and we must always look out for these opportunities. So I really want to just make your point again and emphasize how important this is and how important the work of PGA is. There is another aspect to it, and you know, you talked about Syria, other people have talked about Syria, and Syria is, I think, the most obvious failure in a way of the Security Council in this respect. You know, a conflict that has been fought for pretty much a decade now, or pretty soon, with you know, a strategy of committing war crimes, a strategy of committing crimes against humanity, and that being considered by some as a winning strategy. So the outcry over Syria is certainly the loudest, combined possibly with you know, the crimes committed in Myanmar. But I think an important lesson from Syria is also that we did have the veto in 2014, when, you know, after the referral was proposed, with I think over 50 states supporting this as a co-sponsor. But this was not the end of the road, because the effort to bring accountability for the war crimes and crimes against humanity committed in Syria did continue. So we did look for other options, saying, okay, the road to the ICC is blocked, and realistically, it will remain blocked. We have no, you know, there's no ground for us to assume that the Russian Federation or the Chinese delegation, for that matter, would now look at this differently. So it's pointless to go back and try to send this to the ICC again. But we have found other ways. We have created the IIIM, the Syria Accountability Mechanism, and there are tremendous efforts on the way to hold people accountable on the basis of universal jurisdiction in European judiciaries. And that, in my view, is due in no small part to the fact that we do have an ICC, and that we do look at accountability and impunity differently now than we did 10, 15 years ago. So the road does not end there. You know, if you look at, you know, politically, I do not think that another referral from the Security Council to the ICC is realistic in the imminent future. But this should also be, you know, a big incentive for us to work both towards universality and to looking for other ways to make sure there is no impunity, because that is ultimately the purpose of the Rome Statute. It's not that everybody ends up before the ICC in The Hague. The purpose of the Rome Statute is to make sure that there is no impunity for these for the most serious crimes. I am reading the chat function, but I do not have a question right now, but it's certainly not too late either. So anyone want to come in on this, or should I give back to you, David?
Well, if there is no additional comment, I think it's important for us to recognize really the role of Justice Richard Goldstone. We had enormous expectations at the beginning of the year, and I want to signal here that it was a letter that Christian, you co-signed with the 3 other former chairpersons of the Assembly of State Parties, that back in 2018 triggered this process that last year made the Assembly of State Party to set up this independent expert review. Richard Dicker and other colleagues from NGOs made an enormous work also to create political support among states. So now that we have the report done, the job done, this is really now the time for us to make a very, very big effort to improve the workings of the court. So I really want to pay a tribute here on behalf of PGA and if I can also my colleagues who work in this very difficult field of international criminal justice to Goldstone and his team, because they wrote an incredibly instrumental report. We might not agree 100% on everything there, of course, but the essence is the direction where to go. And I think states now have a duty to take action, and hopefully parliamentarians will be able to interact with their foreign ministers or their delegations to make sure that action is taken. So I maybe wanted to ask Petra and Richard Goldstone to comment on what do they think parliaments could do to further give impetus to this report and the reforms that, as every other international institutions, also the ICC need.
Richard Dicker would like to raise a question.
Oh.
Maybe we take him before. Yeah.
Thank you very much, Petra, and thank you to the presenters. I wanted to make a point, but I'll make it briefly and ask a question. The point is exactly along the lines of what you were sketching out, David, in terms of appreciation about the independent expert review report, and what an excellent document it is, and the potential that it affords court officials and all stakeholders. I could not underscore our appreciation along those lines, acknowledging, as you did, David, a moment ago, that that does not mean agreement with every finding and every recommendation, but this is an excellent roadmap for the court and stakeholders to put the ICC on a solid footing, and we will be working as diligently as we can to see that happens. But my query is on a different topic, one that has been mentioned here. And because we are in a group of parliamentarians, I thought it might be particularly relevant. And that is the aspect that Ambassador Venvasser touched on in regard to political support for the court when it is needed. And in particular, the moment that we are in, and Ambassador Venevasser said he thought it was a good moment, or we were in a good moment. And I would agree with that, but just add to that the fact that there is an opportunity to push back against the policy the Trump administration had formulated on the court, and in particular, the US administration executive order, a very harsh penalty on important officials at the court. My thought is it is a moment to press the incoming administration for repeal of that executive order. And my question is for Ambassador Venevasser, as well as Judge Goldstone, if you feel you can speak to it, why is it important that an incoming administration in Washington repeal this executive order? How will that help the court in the context the institution, the ICC, is currently in? And finally, what might parliamentarians do in pressing their governments to convey at the highest levels the imperative of repealing the order? Thank you very much.
Thanks, Richard. I think we're on a bit of time pressure now. We have another question from Mr. Innocent Gornese. I hope I'm not mispronouncing your name too badly. We also have a question in the chat on Ethiopia that I would like to ask all of us to look at. And then I think we have to wrap up at 4. I certainly have an obligation after that. So maybe we do this quickly and we all panelists include answers in their very final brief comments. So Mr. Gornese, please, Innocent Gornese.
Thank you very much. I even pronounced the 2 badly. It's very much on point. I really want to comment Mr. Goldstone's presentation. I think it was very enlightening. My comment really relates to the issue of trying to get as many countries to ratify the Rome Statute. And in particular, I have heard the comments regarding the use of the veto power, which is of some concern. And I was also looking at the efforts that we are making, whereby we want to get parliamentarians to influence their governments to try to support and get ratifications of the Rome Statute. And in this regard, I was going to ask the Secretariat, the PGA Secretariat, as to whether any efforts have been made to try to get legislators from important countries such as Russia, such as the United States of America, which have been using the veto power in some circumstances, either to protect countries which they associate with, because some of the involvement in some of the wars in countries like Syria, Yemen, and so on, does not involve the direct participation of the superpowers themselves, but obviously they have interests. So my question really relates to the issue of whether some effort has been made to try to get congressmen or senators from countries such as the USA to be part and parcel of the membership of the PGA as a leverage to try to get those countries to get on board. That's really what I want to find out, because I appreciate that as parliamentarians, our role is to try to influence government policy in regard to the ratification of the Rome Statute, so that as many countries become bound by it. Because as it stands now, the main challenge is that it's only those countries which are part and parcel of the statute where the court would have jurisdiction unless a case is referred by the Security Council.
Thank you so much. So very briefly, maybe first back to you, Petra, maybe in particular on the role of parliamentarians, then Richard Goldstone, and I'll offer a few.
Yeah, I'd like
very
to take
brief seconds.
two of the questions. First of all, is the one, the role of parliamentarians. I think that laws always need acceptance. We see that especially now with COVID measures, which are not accepted everywhere because they are somehow often done in a way that is really questionable. And international law needs acceptance too, very well, but that's often very abstract and very far away. So I think that the role of us as legislators is also to translate international policy to our constituencies, to make them understand why it is important to fight impunity, why it is important also for them to fight impunity, because also in my country, it could happen that there could be a case which couldn't be dealt with clearly in an Austrian court. Maybe it's not very likely, but it could happen as well. But we have to translate it. My first answer, and the other on Ethiopia. Yes, absolutely. I am totally concerned. I think that's also a sign that you have to think a little bit before you give somebody a Peace Nobel Prize and don't know him really just because he did one thing fine. That doesn't mean everything else is also fine. As Ethiopia is a partner country of the Austrian Development Corporation, and I have a plenary session right now, and we'll have to leave then again because then we are voting. We also will vote about a motion where we call our Minister for Foreign Affairs to take diplomatic action on the case of Ethiopia and to get active. And especially the Tigray region is our main priority region in Ethiopia. So we are really involved somehow. And I think it's also very important to find ways how parliamentary diplomacy can also work in this case. And so that's the first step we are doing today in our National Assembly's plenary, but there are, of course, many more steps to follow to solve this conflict, no question.
Can I make just a couple of concluding comments?
Yes, please, Richard.
Yeah. Firstly, to express my gratitude to you, Christian, to David, and to Richard for the very kind remarks you made about the report. We were obviously had no doubt that some of the recommendations are going to be seen as controversial. Some people may like them and some people may not like them, but that's the nature of the report. I would add that we took into account a number of issues that are not expressed explicitly in the report. The one is the funding for the ICC. That's crucial, and in the post-pandemic world, it becomes even more difficult. And we were very conscious in trying to make recommendations that would be implementable more or less within the current budget of the International Criminal Court. We took into account too the independence of the judges and the office of the prosecutor, and tried our best not to make any findings or recommendations that would transgress on that independence. So it was a difficult issue. I must say on many issues we had to fight very hard within our group of 9 to reach agreement. There was controversy within the 9 of us, obviously. But I would conclude by really thanking the ASP for having put together such a very collegial group of women and men that made up the IER. And certainly I would stress the obvious, and that is that the role of parliamentarians is crucially important. It's the politics and the funding of the ICC that is absolutely crucial and in the hands of the Assembly of States Parties. Thank you.
Thanks a lot, Richard. I really think, we owe you a lot of gratitude, and the members of the IER. It's really terrific that you did that with so much professionalism and passion for international criminal justice. I just want to make 3 very brief concluding comments. on the questions we're already past time. On Ethiopia, Petra has talked about this. I think it's very important that we do use our existing relationships, bilateral, and so on. But we also need to talk about this publicly and ask public questions and make it very clear what our expectations are vis-a-vis respect for IHL and for international human rights law. It's certainly a very concerning situation also that has a potential to take on an international dimension very quickly, and it already has. So it's very good that it was flagged in this call. On the US measures, you know, if the executive order is revoked, I think that it will have enormous, in a way, symbolic value in more than one way, but it also has a very practical impact because the measures have kept the court very, very busy. So the court has invested a lot of time and of its resources to simply guarantee business continuity to, I think, an extent that most people are not aware of. So this has really undermined the court and also cost us a lot of money. In a way, we like talking about resources, but a lot of the resources that we invest in the ICC have gone into ensuring business continuity. So in that sense, it's also practically of enormous importance. And finally, just on the IER, I did say it's the perfect moment for this. I think it is. You know, I just also want to make it very clear that it's very, very important that we get this right and that we take this opportunity and make meaningful change together with the court to put us on a different track and to narrow the gap, quite frankly, that exists between the promise reflected in the Rome Statute, which is a really visionary treaty, and the reality that we sometimes see on a daily basis now. So back to you, David, and your team. Thank you so much, and thanks everybody for participating.
Thank you so much, Christian, Justice Goldstone, Petra, and we are now joined by our president, Margareta Sederfeld. Of course, I cannot recognize all the board members that are with us and all the active members from all over the world. We will now proceed with just 2-3 minutes of delay into the next session. And we have, for the first time in the history of PGA, a guest from the Sudan, who, however, in Khartoum is a recipient of the Sakharov Prize and a member of the current legislative committee that is drafting the new laws for the new Sudan to move into a democratic country that fulfilled human rights and the rule of law, Dr. Salih Usman. Well, he has not internet connection due to shortages in electricity in Khartoum. So we will call him and put him on a live telephone through my microphone. This panel that we are going to have before the one at 4:45 on the United States, and here allow me to answer to the question from Honorable Gomez from Zimbabwe. We will receive a very strong statement from the leading PGA member in the US House of Representatives that I would hope would meet the calls that we received from our honorable member of Zimbabwe. So PGA is really proactively trying to reach out and engage with the US Congress. Different it is regarding the Russian State Duma. PGA has been the only NGO in the history of the Duma to co-host a conference in the Duma itself back in the days of multi-party democracy in the Russian Federation. I'm speaking about the beginning of the year 2003. And the topic was the ICC. At that time, we were supported by a number of parliamentarians. Today, unfortunately, the situation is as such that no single parliamentarian from the Duma joins PGA. But that's a long conversation that we can have. We are, of course, ready to re-expand our membership in Russia as soon as the democratic institutions will be reinforced and reinstated. Regarding the next panel, we are going to discuss on the impact of the ICC on ongoing transition, the fight against impunity in the Central African Republic, and the cooperation between the ICC and the new Sudan. And we have 3 distinguished guests. First of all, our board member and leading member in Africa, Beatrice Epaye, whom I recognize here today from Bangui. We will have over the phone Honorable Salih Osman for the first time, and we are honored for the second time, or maybe I think for the third time, at a CAP-ICC by Mr. Amadi Ba, who is the head of the International Cooperation Division at the International Criminal Court Office of the Prosecutor, who has been quietly participating in the entire proceedings. So, Honorable Amadi Ba, you are really welcome to be with us today. Pour commencer, je vous invite à parler, Honorable Béatrice Epaille. You will be speaking in French. Béatrice Epaille is the long-standing member of PGA in Central African Republic. She occupies a number of positions in the Foreign Affairs Committee, and she has been heard many times by international institutions, including the United Nations Security Council, on the situation in her country. Honorable Béatrice Epaille, vous avez la parole.
Merci beaucoup. Excellences, Mesdames et Messieurs, chers collègues parlementaires, je souhaite d'abord remercier le groupe national de PGA aux Pays-Bas, ainsi que PGA pour l'invitation à participer à cette 11e Assemblée consultative des parlementaires sur la Cour pénale internationale et l'état de droit. C'est un honneur d'être ici avec vous et je tiens à saluer les membres de ce panel. Le thème de cette session est d'une importance capitale pour comprendre l'impact que peut avoir la Cour pénale internationale sur les processus de construction de la paix et de la consolidation de la justice dans des pays comme le mien. Je suis une députée de la République centrafricaine et présidente de la Commission des Affaires étrangères à l'Assemblée nationale. Comme vous le savez, mon pays a une longue histoire d'instabilité politique avec en toile de fond des conflits armés et intercommunautaires. Le pays continue de faire face à des cycles de violence récurrents qui exposent les communautés à de graves violations des droits humains. Ces violations qui entravent non seulement les efforts de paix menés, mais également le développement économique du pays, le laissant extrêmement vulnérable à la pandémie de Covid-19. Depuis 2012, la République centrafricaine est le théâtre de graves violations du droit international humanitaire ou des crimes contre l'humanité, crimes de guerre, voire des actes de génocide ou de nettoyage ethnique auraient été commis. Malgré une situation sécuritaire difficile, je tiens à mentionner que beaucoup d'efforts ont été faits pour traduire en justice les individus responsables d'avoir commis ces atrocités. Ces efforts se sont effectués tant au niveau national qu'international. La République centrafricaine est un État partie au statut de Rome de la Cour pénale internationale depuis le 3 octobre 2001. En vertu du principe de complémentarité,
Doutor, não esquece de ser mais forte, tá?
Vous me suivez?
Now
Les
it's okay.
juridictions centrafricaines, c'est bon?
Yes, it's okay. I couldn't.
Les juridictions centrafricaines ont la responsabilité première de connaître des crimes internationaux commis sur son territoire. Malheureusement, la faiblesse des institutions judiciaires et du cadre normatif n'ont pas permis aux juridictions nationales de faire leur travail de manière optimale. Ainsi, l'État centrafricain transféré à 2 reprises la situation à la CPI. 2007 a porté sur des crimes présumés commis en 2002 et 2003 dans le contexte d'un conflit armé entre le gouvernement et des forces rebelles. Le 30 mai 2014, le gouvernement de transition de la RCA a renvoyé la 2e situation devant le bureau du procureur afin que son bureau enquête sur des crimes relevant de la compétence de la Cour présumés commis sur son territoire à compter du 1er août 2012. La 2e enquête a été annoncée le 24 septembre 2014. En matière de coopération entre la République centrafricaine, ses partenaires diplomatiques et la Cour pénale internationale, il faut saluer les progrès effectués et l'engagement des autorités nationales à traduire en justice les auteurs d'atrocités et à lutter contre l'impunité. Ainsi, le 9 juin 2020, la coopération des autorités centrafricaines, françaises, tchadiennes et la MINUSCA a permis la remise à la Cour pénale internationale de M. Ali Kouchaïb, accusé de crimes de guerre et de crimes contre l'humanité qui auraient été commis entre 2002 et 2004 dans la région du Darfour au Soudan. Le contact permanent et la coopération entre la République centrafricaine et la CPI, ainsi que d'autres acteurs engagés pour la promotion de la justice internationale, a permis une consolidation de la justice en RCA et l'augmentation des capacités des opérateurs juridiques. Ces échanges ont également permis la sensibilisation de la population qui a bénéficié de plusieurs visites des fonctionnaires de la CPI. Les initiatives de la consolidation de l'état de droit, de lutte contre l'impunité et la promotion de la paix au niveau national continuent de progresser. Je souhaite en mentionner certaines qui sont emblématiques. Le 22 avril 2015, le Conseil national de transition centrafricain a adopté à une grande majorité la loi portant création d'une cour pénale spéciale en République centrafricaine. Cette cour, chargée d'enquêter sur les graves violations du droit international humanitaire commises sur le territoire de la RCA, notamment les crimes contre l'humanité, crimes de guerre et génocide. Ce vote a constitué une étape importante. Les crimes atroces commis à l'encontre de victimes centrafricaines choquent l'humanité tout entière. Et en poursuivant leurs auteurs, la Cour pénale spéciale, en complémentarité avec le travail de la CPI, agit pour le compte de la communauté internationale dans son ensemble et permet ainsi à la République centrafricaine de respecter ses obligations internationales et son devoir envers les victimes. Le 20 février 2019, la Chambre préliminaire de la Cour pénale internationale a décidé de joindre les affaires le procureur C, Alfred Yekatom et Patrice Edouard Ngaïsona. Comme vous le savez, le 29 octobre 2018, les autorités centrafricaines ont arrêté l'ex-député Yekatom, ex-rebelle anti-Balaka, comme on dit chez nous. Le 17 novembre, M. Yekatom a été remis à la Cour pénale internationale et transféré à La Haye. Il est soumis à des sanctions de l'ONU et serait responsable de crimes contre l'humanité et crimes de guerre sur le territoire de la République centrafricaine entre le 5 décembre 2013 et août 2014. Un autre dossier est celui de M. Patrice Edouard Ngaïsona, ancien ministre des Sports et vice-président de la Fédération nationale de football. Il serait responsable de crimes contre l'humanité et crimes de guerre commis en République centrafricaine entre 2013 et 2014. Il a été arrêté le 12 décembre 2018 par les autorités nationales françaises et transféré à la CPI le 23 janvier 2019. Le 6 février 2019, un accord politique pour la paix et la réconciliation en République centrafricaine a été signé à Bangui par le gouvernement centrafricain et 14 groupes armés à la suite de pourparlers menés à Khartoum du 24 janvier au 5 février 2019. Ceci sous les auspices de l'Union africaine, des Nations unies et de la Communauté économique des États de l'Afrique centrale, CEAC. Le 22 janvier 2020, la loi instaurant la Commission Vérité et Justice, Réconciliation et Réparation a été officiellement présentée au président de la République, professeur Faustin Archange Touadéra. Cette commission est l'un des piliers de l'accord de paix du 6 février 2019 dont je viens d'en parler. Le délai de 3 mois prévu dans la signature de l'accord a été dépassé, mais les dispositions visant à élaborer le projet de loi ont été respectées, y compris sur l'organisation de consultations populaires dans les 7 grandes régions administratives. Au total, 1977 participants issus de différentes composantes de la société ont pu être consultés et les travaux ont été compilés dans un rapport. Ce rapport qui a servi de base pour la rédaction du projet de loi. Un jury a été mis en place pour le recrutement des commissaires de la Commission Vérité, Justice, Réparation, Réconciliation. À travers ces exemples, je souhaitais brièvement illustrer l'impact que le système du statut de Rome autour de la Cour pénale internationale peut avoir sur la consolidation de l'état de droit au niveau national. Nous sommes conscients que ce travail n'est pas encore terminé et nous continuerons à œuvrer pour la consolidation des institutions nationales, notamment du pouvoir judiciaire. Sans justice, il ne peut y avoir de paix durable. Je vous remercie.
Thank you, Beatrice. And the work you have been doing in the Central African Republic is extraordinary. All these progresses could have not taken place without the proactive engagement of members of parliament. And certainly you have been one of the most outstanding leaders, creating bridges with the international community, with the African Union, with the United Nations, with every force that has tried to support the transition in the Central African Republic. And now, with a bit means of fortune, we are linking to Khartoum with Dr. Salih Mahmoud Osman. Mr. Osman, are you listening to us?
Yes.
Very good. Very good. I will briefly introduce you and I will ask you to make a presentation of very few minutes, no more than 5 if possible, given that probably the audio will not be ideal. Just to tell to everyone at the Consultative Assembly of Parliamentarians on the ICC and the rule of law how happy we are to have you with us. It's the first time that we have a Sudanese lawmaker, naturally now in a transitional framework, connected with us. We are a global organization supporting human rights, and you have been entrusted with the Sakharov Award for Freedom of Thought by the European Parliament when you were fighting for the rights of the Darfuri populations. You are a leader of the Darfuri Bar Association. You are the president of the board member of the African Center for Justice and Peace Studies. And you are now pivotally a member of the Parliamentary Legislative Committee in the Sudan. Honorable Osman, we would really appreciate if you could share with us your thoughts about the impact of justice and including the intervention of the ICC in support of the transition to democracy and human rights in the Sudan.
Thank you very much. I am truly honored to be hosted and invited to participate in this important panel. But let me just correct a very simple fact that I am an ex-parliamentarian. I was in the parliament of the interim period from 2005 to 2010. Right now, I am not, there's no parliament in Sudan exactly, but we were working always on issues of justice and legislation. That is to bring the laws here in Sudan into conformity with the international standards. As so many people know that for a long time, our judicial system has been described as incapable and unwilling to provide justice because the three serious international crimes, that is genocide, war crimes, and crimes against humanity, were not in our penal code until the 2009. But this is why, because there were no these provisions in the penal code that the courts in Sudan could not take criminals who were implicated in the commission of these heinous crimes to bring them into court. Right now, yes, I will go now to tell you that situation in Darfur that witnessed horrors since the eruption of the current conflict in 2003, many people may not be aware of the fact that hundreds of thousands of innocent civilians have been killed, but millions have been forcibly displaced from their homes. More than 2 million people are still confined in IDP camps, that is internal displaced camps inside Sudan. Other numbers are outside the country, neighboring countries. But the fact is that genocide, war, and crimes against humanity, war crimes have been committed in a widespread and systematic pattern. Villages, communities have been completely destroyed by government helicopter gunships, anti-nuclear crafts, and the dangerous attacks on the ground. Omar al-Bashir and his government were responsible for that, for these horrors. Omar al-Bashir was not facing any kind of justice here inside Sudan until the situation of Darfur had been referred by the UN Security Council to the ICC. That was kind of hope for millions of victims and survivors who were the victims of the policy, that policy of that regime. Today, after the indictment of Omar al-Bashir and the arrest warrants that have been issued by the ICC, victims were very much confused because of the delay that has taken place. But months ago, when the prosecutor came here to Sudan and Khartoum, their hopes were revived, and they are looking forward to see justice done, because Omar al-Bashir cannot be tried here in Sudan. Still, the environment is not suitable. We have the same laws that allow the occurrence of these crimes in the country. Laws have not been changed even after the revolution. That is like now 1.5 years, no law has been seriously, no legal reforms has taken place to change the environment. This is why still the situation is the same. We have this problem of the independence of the judiciary, which was one of the problems and elements that there was no justice in our country. today we have also laws that are encouraging impunity, and culture of impunity is all over the country. It's not Darfur alone. We have incidents, even the massacre that occurred in front of the military headquarters in Khartoum here. Impunity is still there. Nobody, Umar al-Bashir and the five top officials that have been identified by the ICC are still beyond the reach of justice. This is why we, human rights defenders here in Sudan, are very much insisting that it is only the ICC that can have this the responsibility to try Omar al-Bashir. It's not the hybrid course, it's not national course, because the ICC is the only international criminal tribunal that can be trusted by the victims of that.
Thank you, Honorable. And we would hope that when there is a transitional parliament, a politician and human rights defender like you may be able to represent the people of Sudan and then join the PGA and work together towards the same objectives of justice, accountability, democracy, and human rights. Honorable, I am now going to give the floor to Mr. Amadi Ba, who is the leader in the Office of the Prosecutor in the topical area of international cooperation and judicial assistant. He's a judge seconded at the highest level from the Cour de Cassation of Senegal. And I believe he was with the prosecutor in her trip to Khartoum. Let me just say, Honorable, that PGA saluted with great enthusiasm the decision of the transitional authorities of the Sudan to remove a legislation that would have impeded any form of cooperation, including the trip of the prosecutor to Khartoum. So at least that step, we understand, has been undertaken. But as you say, now it's time to continue and bring justice to the victims and finally have the person who is presumed innocent until proven guilty before a court of law. Honorable Amadi Ba, the floor is yours. Thank you.
Thank you very much, Donald. Allow me to make my presentation in French. I will be more comfortable in that language, unfortunately. Je voulais remercier les organisateurs de cette rencontre et transmettre les salutations de Madame le procureur et de l'ensemble du bureau du procureur et féliciter PGA et son antenne hollandaise pour ce travail de renforcement des capacités de sensibilisation et d'appui à la justice internationale. En 2020, nous nous souvenons toujours et nous sommes dans la pandémie, mais malgré le contexte de la pandémie, la situation au sein de la Cour continue à évoluer. Nous avons 13 situations et 7 affaires pendantes devant les juges. Et vous m'avez demandé, à travers ces 7 affaires, de vous faire un état de la coopération, c'est-à-dire un bilan en Afrique, en Centrafrique, en République centrafricaine et au Darfour, de l'état des procédures et de la coopération et les défis que nous rencontrons. Brièvement, permettez-moi d'abord de vous parler de l'état des procédures rapidement dans ces 2 procédures, de l'état de la coopération avant de vous parler des défis majeurs auxquels nous sommes confrontés dans ces 2 situations. D'abord, des pays de transition ayant traversé des crises respectives ayant entraîné des crimes, alors que Darfour, la situation au Soudan nous a été référée par une résolution des Nations Unies. Celle de la Centrafrique fait l'objet d'un renvoi, comme l'a dit son Excellence, honorable député, par l'État centrafricain dans des crimes commis entre les Séléka, le camp des Séléka et le camp des Anti-Balaka, crimes commis et qui ont entraîné une crise profonde. Madame le procureur a ouvert son enquête, a mis sur place 2 équipes et le résultat de ces enquêtes a produit, comme l'a dit son honorable, à l'arrestation de Yakatom, à la remise par l'État centrafricain et par l'arrestation de Ngaïsona par les autorités françaises. Les juges ont joint les 2 procédures et le procès se déroula au 9 février 2021. tandis que la situation au Darfour, renvoyée par le Conseil de sécurité, 5 mandats d'arrêt non exécutés à Ahmed Haroun, Koushaïb, Hassan, Al-Bashir et Banda, 5 mandats d'arrêt de 2005 à 2020 n'ont pas été exécutés. La révolution que vous connaissez a renversé Bachir, qui a été arrêté avec Ahmed Haroun et Hassan pour des crimes économiques et des crimes commis au cours de la révolution. Koushaïb s'est livré volontairement à la Centrafrique, qui nous l'a livré. La confirmation des charges se déroulera le 22 février 2021. C'est ça les procédures. Comment se présente maintenant la coopération? La coopération avec la Centrafrique, comme l'a dit son Excellence, Madame la députée, honorable députée, se passe très très bien avec les autorités, le système des Nations Unies, les ONG internationales comme centrafricaines. Nous avons eu la remise de Ongwen grâce à la coopération centrafricaine. Nous avons eu la remise de Koushaïb grâce à la coopération centrafricaine. Nous avons aidé au démarrage de la Cour pénale spéciale, à son opérationnalisation, au démarrage de ses premières enquêtes, et grâce au stratégique Goal 6, nous continuons à échanger avec la Cour pénale spéciale des informations et des techniques d'enquête. L'accord de Bangui a fait référence à la CPI et a mis en branle la nécessité d'une justice en Centrafrique pour renforcer la paix, Madame l'a dit. Tandis que au Soudan, évaluer la coopération serait prématuré. Je ne vais pas m'aventurer sur ça, je vais conclure sur ça tout à l'heure. Avant, de 2005 à 2007, la Cour a pu faire des missions au Soudan. Mais dès les premiers mandats d'arrêt contre Haroun et Koushaïb, le Soudan nous a fermé la porte. Non-coopération depuis 2007, renforcée et exacerbée par les mandats d'arrêt donnés contre al-Bashir, celui de 2009 et celui de 2010 sur le génocide. Avec la révolte, Bashir a été arrêté. L'accord de paix de Djouba d'octobre 2020, comme l'accord de Bangui, encore une fois, mentionne la justice, la coopération avec la CPI, des similitudes incroyables pour ces deux pays de transition. C'est-à-dire la justice est au cœur de la rhétorique, la justice est au cœur des stratégies, la justice est au cœur des plans d'action, même si la paix et la réconciliation constituent une composante. Voilà les similitudes entre les deux. Quels sont les défis? Dernier point. Les défis, comme vous le savez, c'est chaque fois qu'il y a tension, justice et paix, chaque fois qu'il y a justice et paix retenues comme priorité, selon le temps de la justice, selon le temps de la paix, il y a toujours des problèmes liés aux enquêtes. Le Covid a joué un rôle important. Vous savez, pour partir, il faut tester. Pour arriver, il faut négocier la quarantaine. C'est mon bureau qui s'occupe de négocier avec les autorités. Si les collègues qui arrivent sont testés négatifs, il doit pouvoir interviewer les témoins en respectant les distanciations sociales. Beaucoup de difficultés que nous avons eues et observées durant cette période de pandémie en Centrafrique. Il y a eu des problèmes de sécurité. Heureusement, Madame l'a dit, nous avons essayé au mieux de franchir ces obstacles liés à la sécurité et d'avoir accès aux témoins. Madame le procureur y a fait une visite de prévention à cause des élections de décembre pour dire, nous sommes encore là, nous continuons nos enquêtes, nous avons 2 mandats d'arrêt, mais les enquêtes se poursuivent et je continue à regarder, à observer le comportement de toutes les parties durant la période électorale. Les défis au niveau du Soudan. Aucune autorité officielle, aucun agent de la CPI n'a été au Soudan depuis 2007. 13 ans de blockout. Et un beau jour, explosion, renversement du gouvernement, et nous commençons un long processus de négociation avec les autorités, malgré le Covid. Et ces engagements ont donné quoi? La présence de Madame le procureur et de son équipe à discuter avec les autorités, à rencontrer les autorités politiques, judiciaires et militaires, à expliquer le fonctionnement de la CPI, à rappeler aux autorités soudanaises leurs obligations, à parler aux victimes et la nécessité de prendre en charge les intérêts des victimes, l'accès aux preuves et la complémentarité. Vous voyez que nous avons des difficultés à accéder à certaines victimes qui sont au Darfour. Nous avons des difficultés liées à la sécurité, des difficultés parce qu'il y a un dosage militaire-civil dans le gouvernement. Une difficulté au moment où on vous parle, ils sont encore en train de réfléchir sur est-ce que c'est une justice nationale, est-ce que c'est une cour spéciale ou au modèle centrafricain, ou est-ce que c'est la CPI? Dans tout cela, je veux vous assurer et vous rassurer que nous sommes en contact permanent avec les autorités soudanaises dans l'intérêt des victimes et dans la mise en œuvre de la justice pénale internationale. Nous avons les défis qui sont énormes, pas seulement la sécurité, mais le départ prochain de l'UNAMID, qui est un soutien logistique, qui nous permettait de couvrir le territoire, il va partir. Nous avons des défis linguistiques, nous avons la langue fou, Zagawa et Massalit, nous ne trouvons pas encore d'interprètes. Alors, vous voyez qu'en plus des problèmes que nous rencontrons en Centrafrique, qui sont plus des problèmes de sécurité et de tension justice-paix et la nécessité de continuer nos enquêtes, ici, les défis sont plus encore transversaux et horizontaux. Nous avons politique, sécuritaire, militaire, mais pour conclure, c'est l'optimisme. Comme je disais il y a quelques années en Ukraine avec PGA, l'optimisme habituel du bureau du procureur et de Madame le procureur. La justice est en train d'identifier des points focaux au Soudan que nous consolidons au plan politique, diplomatique et opérationnel. Un accord et un projet de négociation comme nous l'avons avec la Centrafrique. Des questions de complémentarité sont en discussion que nous ne pouvons pas déflorer en public. Des réformes judiciaires et juridiques sont en train de mettre en œuvre, qu'ils s'engagent, sur lesquels PGA et d'autres acteurs peuvent travailler. Et vous voyez que les accords de paix de Juba et de Bangui se rejoignent dans la mesure où on parle de justice comme priorité, comme l'a dit Madame, sans oublier la paix. Et comme nous avons une justice nationale qui va essayer de faire son travail, avec une justice pluridisciplinaire, internationale ou régionale, la Cour pénale, sans pour autant oublier la nécessité de renforcer la paix et la réconciliation. Et tout ça fait que c'est un contexte extrêmement difficile, mais sur lequel nous avons encore les mêmes optimismes que nous l'avons sur le passé. Pour conclure, 2 pays de transition politique, frontaliers, ayant des systèmes judiciaires similaires, parce que souvent très faibles, une crise profonde marquée depuis des années, une instabilité politique, militaire et civile, mais qui fait de la présence de la CPI et de la justice un pilier majeur de la stabilité et de la construction de ce pays. Et nous pensons qu'avec les accords de Bangui et de Juba, bien appliqués avec le renforcement de la justice nationale et internationale, la reconstruction durable, comme l'a dit Madame, passera certainement et sûrement par le refus de l'impunité. Et là, PGA et tous les acteurs internationaux et régionaux ont un rôle à jouer. Je vous remercie.
Merci beaucoup, Amadi. I think you gave really a vibrant illustration of how peace and justice go hand in hand. And we have 3 speakers to end the day. We have Jim McGovern from the US Congress, Professor Meg de Guzman from Temple University. So there is a small component of our program on the US and the ICC. and then the conclusions of our president, Margareta Sederfeld. So let me give maybe 5 minutes for questions or comments on these excellent presentations that we heard, notwithstanding the technical difficulties from the Sudan and of course from Central African Republic and from The Hague. Is there any question, comment on peace and justice, issues of amnesties, whether you are confronted with them? Okay, I don't see any. I would like to ask my colleague in the PJ Secretariat if there's any question or any request. Okay. If not, then I think that what we tried to showcase, dear members of parliament, is two situations where the impact of the intervention of the ICC is positive. It takes a long time. That's the case of the Sudan, where it took many, many years of Mr. al-Bashir to travel all over the world, and then finally by his own people being put in under arrest, and then eventually better sooner than later surrender to the ICC, and then to face justice also for other offenses that he might have committed, such as the economic crimes that Amadiba mentioned. And then a situation like the one in the Central African Republic, where it's really the engagement every day of activists, lawyers, civil society, parliamentarians like Beatrice Paye, and the United Nations through MINUSCA and all the donors community, the African Union, to create the conditions for finally giving hope to a better future to all the victims of mass atrocities in the multiple conflicts that affected the Central African Republic. But we do believe that if Sudan stabilizes, then this will give better chances also to Central African Republic due to the many interferences of the past regime into the stability of the Central African Republic. And we in PJ remain very strongly supportive of any effort in support of peace, security, stability, and of course, justice and human rights. Now we are going into the discussion on the US position on the Rome Statute system against impunity. And I invite the team of PGA to broadcast the intervention of Representative Jim McGovern, who is the co-chair of the Tom Lantos Human Rights Commission in the US Congress and a long-standing member of PGA. Mr. McGovern.
Good afternoon. I'm Congressman Jim McGovern, co-chair of the Tom Lantos Human Rights Commission in the United States Congress. Thank you for inviting me to address the 11th Consultative Assembly of Parliamentarians on the International Criminal Court and the rule of law. I've been asked to speak about the United States position on the Rome Statute and the International Criminal Court. As you surely know, the U.S. position is complex and contradictory. We initially supported the idea of an International Criminal Court and participated in the Rome Conference, but we voted against the Rome Statute. Once the treaty was approved, we signed it on the last possible day, but we have not ratified it. The Bush administration declined to cooperate with the court. The Obama administration reversed that position and collaborated with the court's proceedings to the extent possible under U.S. law. Then came the Trump administration, which not only reversed course again, but has vilified the ICC, attacked its legitimacy, and slapped sanctions on its personnel for doing their jobs. When the sanctions were announced last September, I said that the Trump administration had undermined American leadership on human rights and isolated our country on the world stage. I thought the decision to sanction was a slap in the face to victims of atrocity crimes around the world that would not stand the test of time. That is still my view. The United States has just elected a new leader. President-elect Joe Biden believes in human rights and supports multilateralism. Now, I'm not speaking today on his behalf, but I hope and expect this incoming administration will restore a constructive working relationship with multilateral institutions across the board, including the ICC. I expect the new president to lift the sanctions imposed on ICC personnel, and I will encourage him to do that quickly. I have every reason to believe that under President Biden's leadership, the United States will again be an ally in the fight against impunity for grave human rights abuses wherever they have occurred. We in the United States have a lot of work to do to restore the soul of our nation. Reclaiming our moral leadership by defending human rights and the rule of law at home and abroad will be at the heart of that effort. As the President-elect has said, we should lead the world through the power of our example and not the example of our power. But a return to engagement won't mean that the tensions that underlie the contradictory U.S. approach to the ICC will be resolved anytime soon. We face a fundamental disagreement in the United States between those who concern themselves with human rights abuses only when they are committed by our adversaries versus those who, like me, believe that all governments, including my own, should be held to consistent human rights standards. This is a long-standing division, but it has deepened under the Trump administration to a degree we had not seen since the Cold War. The effect is to politicize discussions of justice and accountability, to instrumentalize human rights for political ends. We have seen this play out in the treatment of the ICC. Yes, there is some consensus in the U.S. on the need for accountability when it comes to the treatment of Uyghurs in Xinjiang, Assad's barbarism in Syria, and the genocidal crimes in Darfur and Burma. You won't find the same level of bipartisan consensus when it comes to when the discussion turns to the murder of Jamal Khashoggi, or genocide, extrajudicial killings and enforced disappearances in Guatemala, Colombia, or El Salvador. You also won't hear consensus on what accountability means. Too often it seems to mean unilateral economic sanctions of exactly the kind that were imposed on the ICC. I believe that economic sanctions are an important tool. I was an author of the bills that created the Magnitsky sanctions, and I support their appropriate use to prevent those responsible for grave crimes from traveling or doing business in the United States. But accountability is much more than that. Accountability is about ensuring justice for the victims in a way that helps restore their lives going forward. It is about society saying that what happened to them was wrong and then working to make sure it doesn't happen again. For that, we need the public airing that judicial processes contribute to, either national or international. Now, I know from my own work on human rights how important that demand for justice is for victims of the gravest crimes. I've seen the power of the hope for justice in El Salvador and Sudan and many other places. And that is why I support the ICC, because far too often national institutions fail in their duty to victims. But I have also learned that no single institution by itself can fix all that has been broken. Yes, we should do all we can to strengthen the ICC. I'm confident that during the next 4 years, the U.S. will contribute to that goal in the ways that we can. At the same time, that effort should go hand in hand with strengthening countries' domestic justice institutions. After all, the ICC is a court of last resort when nations themselves cannot or will not hold their own citizens, militaries, or leaders accountable in the face of alleged war crimes, crimes against humanity, or genocide. The ICC should serve both as a model and as a spur for nations to strengthen their own judiciaries and mechanisms of accountability, including truth-telling and reparations initiatives. And most important of all, we should work to ensure that our own foreign, trade, or arms policies do not in any way contribute to the violation of human rights in the first place. As we strengthen the ICC, we should be also working to make it unnecessary. I wish you well with your deliberations, and I look forward to seeing your recommendations. Thank you all, and please be safe.
Thank you, Mr. McGovern. This is really a statement that we shall widely disseminate, as it indicates really an alternative perspective on international justice and the rule of law in the United States, which, by the way, I believe corresponds to the majority position, given the number of surveys and polls with the American public on these type of issues in the last 25 years. So this brings me to the last speaker of the day, but we have missed an important question from a member of parliament who's joining this meeting from Afghanistan, who requested to speak in Farsi and have his question translated into English by one of our colleagues. So Honorable Abdul Khalik, Honorable Abdul Khalik, you may have the floor if you feel like now. You should unmute yourself. Okay, thank you.
اجازه میگیرم از همه وکیل صاحبایی که در از 130 کشور یک جا شدن و تشکر میکنم از اونها. خدا کنه که یک مدتی که برای ما وقت است و آواز مرم بشنون و از صحبتایشان بسیار دقیق و خوب شنیدم و خیلی خوش شدم و تشکر میکنم از کسایی که برنامه را طرح‌ریزی کردن و یا ساختن که همه نظرات وکیل صاحب‌ها را با گوش همدیگر رساندن. از اونها هم تشکر میکنم.
Thank you, Honorable. Translation.
Okay, I'm gonna go and do the translation now. Thank you so much, Honorable Representative. Thank you for giving the opportunity for us to come here and speak and share our ideas. Thank you for the organizing team. آقای خالق میشه شما ادامه بدین.
و تشکر میکنم از خوان و اینکه در زبان برنامه ما را ترجمانی بکنن، بسیار ببخشند. و ما از افغانستان وکیل بلخ هستم، یعنی یکی از شهرهای افغانستان از بلخ یا مزار شریف. و افغانستان از 34 کشور ساخته شده که همه افغانستان خصوصا یک از نگاه اراضی یک افغانستان کوهستانی هستند و ما از افغانستان هستیم و در ضمنش پارلمان یعنی 249 عضو داره که با کمیته ها تقسیم شده که 15 کمیته داره و ما هم به حیث معاون کمیته سهم شکایت و اوجا به حیث معاونش هستم و خوب است که امروز ما هم عضویت این مجلس شما را دارم. دیگه میشه خواهر ترجمه کنم.
Yes, so His Honorable is speaking about Afghanistan and also the way the whole parliament system works there. The members from 34 provinces that they are coming together in Kabul city and working together. And he's representing one of the largest city in Afghanistan, which called Balkh. And also he is working and he is specifically representing the commission, which hear people complained in Afghanistan parliament in House of Representatives.
Okay, Ruksar, could you maybe can I suggest the following, that you discuss with the Honorable his question. We proceed with the presentation of Professor de Guzman on the US position on the ICC, which is linked to the situation in Afghanistan, of course. And then we collect from you the question, and then we have maybe Mr. Ba or myself or any panelist to address it. Is that acceptable?
Sure, I will convey that message to
Thank
him.
you very much.
Sure, thank you so much.
So I think it's very important that PGA, as we did always, is open to parliamentarians from all democratic countries, and the Parliament of Afghanistan is elected by the people. So we are extremely honored to have the Parliament of Afghanistan represented in our meeting, a place where too many crimes have been committed against too many victims, and especially with the Taliban crimes being under total impunity as of today. Let me now go back to the United States and the ICC. And we have with us a very well-known scholar from the United States, Professor Margaret de Guzman, who teaches international law at Temple University School of Law. She's the director of one of the centers of research there. And she has written extensively in the field of international criminal law, being, by the way, one of the authors of the Trifterer commentary on the Rome Statute since 1999. So Meg looks very young. The reality is that she's one of those who have an enormous experience since the Rome Statute was negotiated, and she was actually present at the negotiations. So we are very honored to have you, Meg. You are one of the 4 American individuals, together with an institution, you made a lawsuit on the certain aspects of presumed illegality of the recent executive order against order of the administrations regarding the ICC. But today we called you to discuss not, of course, your personal position in the United States, which is very serious, and we support you fully in your endeavors, but to present us what sanctions means under both international and domestic law, and what is the proper use of sanctions. As we have heard, the prosecutor and the senior member of the ICC Office of the Prosecutor Office have been sanctioned. So we are very interested to know more from you and from a legal practitioner from the United States, what is the proper law in this very important area of practice in which PGA is also very committed. Thank you, Meg.
Thank you so much, David, and thank you for including me in this really important program. I've been impressed ever since Rome and when we got to know each other there at all of the work you've been doing and your colleagues with Parliamentarians for Global Action. It's really important work, and I'm very honored to be included in this program. In terms of the topic of sanctions and human rights, I decided to title this "The Good, the Bad, and the Ugly." And the good is, generally speaking, when sanctions are used by the US and others to target persons accused of human rights violations. So this has been the traditional use of economic sanctions, travel bans, and the like. The bad, I'm going to talk just a little bit about some of the potential side effects of those kinds of sanctions that can be negative for human rights. And the ugly is going to be the executive order that Donald Trump and his administration signed this summer, and under which it has designated, as you already know. And I wasn't able to hear all of the presentations this morning, but I know that a couple of people have already referenced the executive order. So I'll go into a little bit more detail about that and a little bit about our lawsuit. I want to give the disclaimer that as a result of the executive order, I actually am not able to say pretty much anything supportive of the Office of the Prosecutor. And I take that to be pretty broad, given the, as I'll talk about, ambiguity of the language of the executive order. So I want to just say that nothing that I say today should be construed as supportive of the prosecutor, Fakiso Mochicheko, or the ICC in general. Okay, that being said, I also want to just acknowledge how impressive, thoughtful, and important the remarks of our representative, James McGovern, were just now, and that, generally speaking, I endorse everything that he said. Last thing I want to say by way of preliminaries is that there are at least a couple of people on this call who probably have more expertise than I do in terms of sanctions against human rights violators. And I'll call out in particular my colleagues and friends, Richard Dicker and Steve Rapp, and invite them, if they should wish to do so, to elaborate on anything that I say at the end of these remarks, or to jump in the middle if I say anything that doesn't sound quite right. Okay, so the first thing I want to talk about is, as I say, the good, US sanctions against perpetrators of human rights violations. And those sanctions date back quite a while. They include economic sanctions and travel bans, and they can be authorized by the president or Congress. But Congress has delegated quite a bit of authority to the president to act under executive authority, authorizing sanctions against persons who violate human rights. And this is done through, in the United States, through the emergency powers. So in particular, there's a law called the International Emergency Economic Powers Act. And since that's a bit of a mouthful, I'm going to call it IEPA from here on out, although then it sounds like I'm sort of exclaiming in surprise, but there you have it, IEPA, which allows the president to institute sanctions upon declaring a national emergency with respect to an unusual and extraordinary threat to the national security, foreign policy, or economy of the United States. Now, it's important to note here that the president has very wide discretion in declaring what constitutes such an emergency. Courts have given the president very broad deference in those kinds of determinations. Presidents have found various situations involving violations of international humanitarian law and human rights law to constitute unusual and extraordinary threats, justifying economic sanctions under this law, IEPA. And the Office of the Treasury, there's a part of that office that's in charge of foreign asset control that administers a list of persons who are designated under these kinds of sanctions. And they can involve violations of, the sanctions can involve substantial civil and criminal penalties. It's worth noting here that the sanctions that have to do with human rights fall under the same authority, the same legal framework as sanctions against those involved in terrorism, nuclear proliferation, and narcotics trafficking. And human rights sanctions have tended to be somewhat less strongly enforced than have sanctions for those other kinds of activities. Nonetheless, the United States has issued quite a large array of sanctions, many of which are country specific. So they're quite broad rather than being targeted at individuals. And some of the countries, it's quite a long list, but include Belarus, Burundi, Central African Republic, Cuba, Democratic Republic of Congo, Iran, North Korea, Sudan, Ukraine. As I say, it's quite a long list of countries that have been the subject of these kinds of sanctions for engaging in human rights violations. The representative who spoke just before me mentioned the Global Magnitsky Human Rights Accountability Act. And this is another piece of legislation that allows the government to target specific persons for sanctions when they violate human rights. This was passed by Congress in 2016 under the Obama administration, but it has actually been fairly robustly enforced by the Trump administration. And I will say parenthetically that it is one of the relatively few things that the Trump administration has done in support of, in promotion of human rights. The Global Magnitsky Act targets foreign persons responsible for gross violations of internationally recognized human rights committed against human rights defenders and whistleblowers in any foreign country. And the violations had to be committed under color of law. Now, the Trump administration, again, in one of the rare human rights promoting actions of the administration, actually expanded the reach of the Global Magnitsky Act in 2017 by an executive order that enlarged the kinds of human rights violations that could qualify for the sanctions. They no longer have to be gross violations, for example, and specified that both governmental and non-governmental actors could be sanctioned, so that the actions don't have to be under color of law. And it targets a broader range of persons, both foreign persons who engage in human rights violations, but also any person who materially assists, sponsor, etc., the persons who are engaging in those violations. One thing I want to note here, because it's also relevant to the lawsuit that I'm a part of, is that in this context, as in other contexts involving sanctions that the US administration issues, the term foreign person actually encompasses dual citizens. And I am actually a dual citizen of the United States and Canada, which makes me particularly vulnerable, as I'll talk about in a minute, to the sanctions that the administration has issued related to the International Criminal Court. So again, the Magnitsky Act has been used to designate persons from various parts of the world, including China, Lebanon, South Sudan, Iraq, Uganda, and elsewhere. And one important feature of the Act is that it instructs the government to consider recommendations from civil society. So the Department of State and the Department of Treasury, in implementing the requirements of the Act, must consult with civil society, which gives an opening for civil society to participate in this governmental activity. Although I think it's also fair to say that, that the recommendations from civil society are not necessarily followed. I think they're very rarely followed, and that the government doesn't have any obligation to explain why it is not following recommendations it receives from civil society. I want to note here, although I was asked to talk about the US in particular, that other countries have also imposed sanctions on human rights violators. Many other countries have done this. The UK and Canada have legislation that is similar to the Global Magnitsky Act and have used it. For example, Canada has sanctioned Belarusian officials under their act. And the EU and individual EU states have regulations that are similar to those that I've been talking about. Often they're more targeted than the US sanctions, and they've been used, again, to sanction a wide array of officials around the world, and many other countries do as well. So this is not by any means a feature of US foreign policy. I'll also just mention here that, and David brought this to my attention as we were thinking about my remarks for today, the ICC prosecutor recently mentioned in her statement to the Security Council that the EU has imposed sanctions against individuals in Libya, including one of the persons wanted by the ICC. So this raises what I'm going to call the bad, or the potentially bad, aspect of these kinds of sanctions, which can be unintended side effects. So David mentioned in this exchange on this particular issue that sanctions could become, particularly travel bans, could become an issue in terms of carrying out ICC arrest warrants, and that it will be important in implementing these kinds of sanctions to make sure that the targets of ICC investigations can still be transported to The Hague. Other potential unintended side effects that have to be taken into account in implementation of these kinds of laws are, of course, the disproportionate effect that they can sometimes have on civilian populations. Particularly these blanket country-wide sanctions can be very damaging to the economic, social, and cultural rights of civilian populations. And there's also a problem of some institutions, in particular banks, applying a sort of what they call de-risking to limit their liability, and therefore sort of cutting services even more broadly than they maybe would need to under the sanctions, in order to be very sure that they're not running up against any potential liability. So that's another potential downside. There's also potential violations of other obligations, such as obligations under trade agreements, WTO obligations, and so on. Lastly, in this category, I'll just say that these kinds of sanctions tend not to be very effective unless they have political support, unless they are accompanied by political pressure, in which case any of these downsides that I've just mentioned can be particularly worrisome if they're not actually having the intended effects of promoting or deterring human rights violations, right? Promoting human rights. Okay, this brings us to the ugly. And I think many people around the world agree that Executive Order 13,928 is very ugly, right? This is one of the ugly things that the Trump administration has done in violation of traditionally sacrosanct values of the United States, including the promotion of human rights. So under the same AIPA that I talked about as the basis for sanctions that promote human rights or that seek to deter human rights violations, the Trump administration in June issued an executive order declaring that the ICC investigation or prosecution of US citizens or the citizens of other non-party states is a national emergency here in the United States. An unusual or extraordinary threat to the national security, foreign policy, or economy of the United States, right? Using that language of national emergency that allows the president to issue these kinds of sanctions. So having declared the ICC investigations, particularly with regard to the Afghanistan situation, a national emergency, the Secretary of State was authorized to designate any foreign person who directly or indirectly engages in any effort by the ICC to investigate or prosecute US personnel or the personnel of US allies without that government's consent. And such designations did in fact take place, as you already heard, on September 2nd. The prosecutor of the ICC, Fatou Bensouda, and Fakiso Mochechoku, the head of the Jurisdiction, Complementarity, and Cooperation Division of the Office of the Prosecutor, were both designated under the executive order. And this means that any of their assets are frozen. There's a complete travel ban against them. But it also means that anyone who assists them in any way can be subject to civil or even criminal sanctions. And these terms in the Act, providing assistance, material support, services in support of, are all very poorly defined. They're actually undefined in the Act itself. And it's very difficult to figure out what they mean, even in the implementing regulations for the Act. And so this failure to define these terms means that it threatens a very broad array of actors who might be considered to be supportive of the ICC with either designation themselves, particularly if they're foreign persons like myself, a dual national, or if they otherwise support the efforts of the OTP. So this can include anybody who just even casually is giving advice to the OTP, airlines who transport OTP personnel, hotels where they stay. It's very, very broad. So just to be clear, what the order does is two things. It authorizes the designation of foreign persons who can be subject to these very serious economic sanctions, and it subjects foreign persons or US citizens to enforcement penalties if they provide assistance or otherwise services, et cetera, to those designated persons. And the penalties can be civil penalties of hundreds of thousands of dollars, asset blocks, and criminal penalties of up to $1 million or 20 years in prison. So we're talking about very serious potential penalties for violations of this executive order. Obviously, the intent of this executive order is to demonize the ICC. And if any of you heard the Ambassador Morris Tan talk recently at the American Enterprise Institute, their view is that the ICC should either completely change its statute or be shuttered. So this is in line with those foreign policy goals. The executive order turns IEPA completely on its head, right? It takes a law that was intended to promote human rights, to deter the violations of human rights, and turns it against the very people who are charged with that kind of deterrence at the global level and who are doing such important work. To now be subject to these sanctions is really quite astonishing, frankly, and horrific. So to conclude, the Open Society Justice Initiative, which is a civil society organization that does a lot of work to support the ICC, including advising the prosecutor, along with myself and 3 other law professors who are all dual nationals, have brought a lawsuit challenging the executive order on a number of grounds, including that it violates our rights to freedom of speech and association. And that lawsuit is making its, proceeding in the courts now. But of course, and I'll pick up here Richard Dickard's point from earlier, we now have a new administration, and it's our hope very much that revoking the executive order will be a top priority of that administration. So with that, I conclude. I believe that there is time for questions and conversation, but I'll turn it back to David.
Thank you, Meg. This was really clear, I believe, and you really made a good job in explaining us about this self-imposed national emergency. Honestly, also because nothing has happened in terms of selection of cases or advancement of proceedings. So it was quite a surprise when this happened. I see that Ambassador Stephen Rapp, the former ambassador at large for global criminal justice of the Obama administration for over 7 years, and Ambassador Rapp briefed the PGA board in Washington the same day in which he was confirmed by the Senate. Actually, he came before to our meeting, am I right, Ambassador? And then you went to the Senate to be confirmed. So our heritage, our legacy, linking us to you is the historic board member of PGA, the great senator from Iowa, Tom Arkin, who was in our board for many, many years and was a big, big supporter of your nomination. Ambassador Rapp, do you want to comment?
Well, just the briefest comment, and I know we're running late, and thank you for the great, for the nice remarks, but particularly for the global leadership on these issues. And proud to, I think this is the 4th of conferences that I've been in. The other 3 were Rabat and Rome, and I think Milan in person. But it's so wonderful having your organization working with parliamentarians, with people that are representing the populations of the world, really taking a lead on these issues. So, but all I wanted to say is I wanted to congratulate Meg and salute her courage and those of the other 3 professors who have filed this lawsuit and Open Society. And I do think one of the things that can be accomplished by this, obviously, we'd like to see this lawsuit, if necessary, proceed to judgments that indeed found that that this was inappropriate and illegal, what the administration did, and strikes down the ability for it to be done in the future. That would be positive. That may take some time, and these cases don't always succeed in the end. But I think the most positive effect here is that the government has responded to the lawsuit. It's now before a judge, and it'll be up to the incoming administration and the incoming Attorney General to take over the defense. And obviously that would involve the new administration in making arguments that are entirely contrary to the kind of things that Joe Biden has stood for, his strong support for human rights, the support he gave us for the arrest of Mladic, for the allowing the ICTY to complete its work, for justice in the Balkans and elsewhere, would be totally inconsistent. And so I think that the effect of this lawsuit will be to accelerate the decision to withdraw the executive order, withdraw the designations, in order not to have to take those kind of untenable positions in court. And I think this will be, I think, the effect of it. And the sooner that this is gone, ideally, in the minutes after the president is sworn in office and before he goes to the parade, if we have one during COVID, this should be one of the scores of scofflaw actions taken by the Trump administration that be struck down, so that we can turn a page and go back to the sort of a partnership that we had with the ICC, the way we were able to use our laws, as Congressman McGovern described, to assist the ICC on a case-by-case basis. But it was because every one of the cases fit the Dodd Amendment, we were able to assist in every case. And as the prosecutor has said, 2 of the individuals most recently tried at the court surrendered to American officers, and we personally engaged in bringing them to The Hague, even in one case several hundred kilometers on a U.S. military flight, so that Bosco Ndaganda and Dominic Ongwen could face justice. And in very good cases that were prosecuted in The Hague. And I hope we can get back to that level of cooperation and that we can work through these issues involving Afghanistan appropriately, which is by showing that we're holding our own people to account with genuine investigations and that therefore there's no need for the ICC to proceed against American citizens. But I mean, we need to engage and show that we're doing that and have done that. And that's the way to deal with these issues, not by actions that attack people who are upholding human rights, following their oath of offices, and represent an institution in which almost all of our best allies are members and active members. So anyway, but thanks to Meg, I think it's going to be perhaps easier to be rid of this sooner rather than later.
Thank you, Ambassador. And the service you have made also as a prosecutor at the Special Court for Sierra Leone is really recognized by all. It's really an honor for PGA to always have you in our meetings. I have also Richard Dicker, the director of Human Rights Watch, willing to speak from New York City. Richard.
Well, thank you so much, David. I'm honored to follow the previous proposals. I should just say, of course, I'm not the director of Human Rights Watch. That's my boss, Ken Roth. So I want to keep on the right side of accuracy there. But I want to thank Meg and Ambassador Rapp for their comments. And I really don't have much to add beyond this point, focusing on the moment we are at now in order to make repeal of the US executive order possible. I think Ambassador Rapp struck just the right note in terms of making this a priority of the incoming Biden administration, but that will most likely happen early if the administration feels concern and interest from allies. And my appeal, again, is to you as parliamentarians, to the organization as a whole, which has done such effective work in so many phases of the ICC effort, to focus now on seeing that your governments convey to the incoming Biden administration and the teams assembled the clear urgency of repealing the executive order. I think that will make a difference because, as has been indicated, there is the potential involvement of US personnel in the Afghanistan investigation, and there is also a potential investigation on Palestine, which will be extremely contentious in the United States and will exert, I fear, enormous pressure on the Biden administration to remain quite critical, if not distinctly opposed to the ICC. So the interventions, we believe strategically, from your respective governments could be quite helpful in making the early repeal of the order possible, rather than allow it to linger and get complicated or more complicated in subsequent events. So that's really my point. And I share Ambassador Rapp's view that hopefully, even with an Afghanistan investigation and a Palestine investigation, it will be possible to get a new US government to focus on the overall value of what the court does and not or rise beyond trying to destroy the institution because it objects to one or two investigations that may be proceeding. In this context, your efforts could be quite meaningful. Thank you so much.
Thank you, Richard. And in fact, I see that Senator Dietrich is still with us since the very beginning of this afternoon. We have been asked by the Tweede Kamer Standing Committee on Foreign Affairs to disseminate a letter they have written to the US Congress, exactly bringing about this type of concerns, Richard. So that's what we are doing with our global membership. But I think a meeting like this is much more important to enter into this very important topic. Now, we have our president waiting for us, and we don't want to make her be late, but I have still the summary of a question from our member from Afghanistan that I will call upon our colleague Ruxar to translate, and eventually this will be addressed tomorrow in the proceedings of tomorrow if it's a complicated one. Ruxar.
Thank you so much, David. Honorable Mr. Khalik, he posed a question regarding the case of Afghanistan because according to complementary jurisdiction of ICC, Afghanistan has the jurisdiction to prosecute that case. But internally, he is there and he's well aware of the justice system, that it's not very strong. So his first question is, if Afghanistan is not, first of all, the justice system is not that strong to prosecute that case, so what will happen to the future of that case? And second, if Afghanistan will be able to prosecute that case, this country is in debt from support from US. So definitely it will be influenced by US officials and currently with political situation. So how we can see that situation will turn out? These are the two main concerns that Mr. Khalik wanted to share.
Well, these are really, really excellent questions. And this brings us to tomorrow's proceedings with the president of the court and the office of the prosecutor, who will join us in a dialogue on issues that are so important. I think what is very clear here for me to say after Meg's so clear presentation is that PGA is a little bit different from all the other NGOs like Human Rights Watch and so on, because since PGA is made of parliamentarians and we advocate and support the separation of powers, we will never take a position on a single case. In other words, it is not the job of members of parliament to tell prosecutors what case to do or not to do. So we are not, in my personal view, we are not touched upon by this executive order at all, because that's not our job. Nevertheless, as Jim McGovern has said, certain things needs to be straightened. And I think what has been happening here is extremely enlightening. Regarding complementarity, and I give up my role as rapporteur of the day, we will have a report tomorrow from our colleagues Frederica and Melissa. I just want to say this. Afghanistan has an excellent law from 2017. We should support Afghanistan to do domestic justice. Then, as the Honorable said, if they are unable to deal with certain Taliban leaders, with certain others alleged major war criminals, then we need the international community support. Then we need to have a burden sharing exercise and get the ICC in to look into the relevant evidence. So far, I think the attitude has not been probably the most cooperative. Hopefully, when the situation in the United States becomes more cooperative towards accountability in Afghanistan, then I think also domestic justice in Afghanistan might have an important future. So I think all things should not exclude the other. And what counts is that the law is applied, no amnesty is given to these alleged criminals, because that was the debate in Kabul, I remember back in the days. It was all about amnesties. Now the debate is about accountability. So let's proceed from there and build for a better future without mass atrocities.
If I may take just 1 second, David, regarding the amnesty, I'm not so sure how much that's applied. It's just my personal view.
No, it doesn't apply, Ruxar. I was not saying it applies, but it was the main topic in the parliament.
Yes, but
I'm sorry to intervene, but I think we should try to stick to the time schedule, because I know that we have been here for 4 hours and quite a lot of the participants have another heavy agenda for the evening, and we have another very, very interesting day tomorrow morning where we start 9 o'clock. I'm sorry to say this, but I know that when we as parliamentarians and particular PDA start a discussion, we could continue for hours, and it's not right for those who have other business on the agenda, and the issues is so important. So it would be good if we have time to handle them serious. That's my opinion. Thank you.
Margareta, this brings us to give you the floor. It's today's proceedings are ended. I really want to thank everyone, even those that had not confirmed and joined us from countries like Yemen and Afghanistan. We are very proud of that. Tomorrow we will restart at 2:00 p.m. in Europe, or 8 a.m. in the United States, or your time zone in Asia and Africa. Margareta, you are the president of PGA.
Thank you.
Please.
Thank you very much, David, Secretary General, and distinguished participants. First of all, I would like to apologize for being a little bit late today, but as parliamentarians, some things happens that we are not, we can't rule over, and it's just to be there when you are told. I would first like to thank you to our host, the PDA group in Netherlands. We are very grateful that you host our CAP, even during this very difficult time with the COVID-19 that affects the whole world. Then I would also like to express PDA's gratitude to all the speakers here. Thank you very much for taking your time and sharing your knowledge and experience. And of course, dear participants, thank you so much for attending this meeting, as well as asking all your important questions. And I'm sorry for interrupting the continued discussion, but I really look forward the days tomorrow, as I hope you as well do, when we will continue this discussion. And as parliamentarians, as what's said here, we are driven of the will to have an impact. We are driven of a will for rule of law and justice. And that's what PDA is for. And that's what we also work to achieve. And as we have here today, 2020 has represented a crucial year for the future of the ICC, with unprecedented reforms and strategic elections. The ICC is set to become even more efficient and better equipped to fight the impunity worldwide. It is worth reminding that the situation of this year has demonstrated the importance of having in place a strong, independent international mechanism that delivers impartial justice to the perpetrators, holding the highest position, even during a crisis, as we have experienced this year. And I would also like to say, as was discussed here about the Magnitsky laws, I think this is also express the importance of laws and rules when the most difficult issue happens. Unfortunately, as we have discussed, the ICC has also faced several challenges. Apart from those discussed today, namely the unacceptable politically motivated measures taken by the US administration, the others include a lack of effective cooperation by both state parties and non-state parties, competing interests, limited resources, political opportunism, the expediency of proceeding, or security and safety issues faced by investigators. And by this, I would also like to mention that I do look forward the development in US for the next year when, well, it's not the final decision done yet, but Biden have received, as it looks now, 270 seats of the electors. And this means, if it continues, that he will be the president. And he have announced that he looks forward for the multilateral engagement for US and also rule of law. And this means that it will also be changes, as I said earlier, in the administration in US. And I could only see that this will be very positive for the rest of the world. And I will also echo that what has already been said earlier today, the ICC needs our support to perceive its independency and fully functional mandate that we, the international community of 123 states, have entrusted it with. And we, members of Parliamentarians for Global Action, we will continue our work to get more support for ICC. One of the highlights of today has been the great statement by our colleague, Mr. James McGovern, from the House of Representatives. He promised and profound a change in the US position on the ICC under the new administration, which shall be inspired by the common values that unite us: human rights, accountability, and multilateralism. Mr. McGovern anticipated that the new administration will remove sanctions against the ICC officials who are doing their job. This will be a very positive development. As parliamentarians, I recognize the key role we play in gathering the effective delivery of justice at both domestic and international level. Through our legislative powers and also our duty to scrutinize our governments, we are able to overcome legal and political challenges that hinder the fight against impunity. We need to use the powers to introduce and pass laws to reinforce the investigative and prosecutorial capacities of our states, incorporate into our domestic codes the crimes under the Rome Statute and the necessary procedures to cooperate effectively with the ICC. And to understand the mandate and functioning of the ICC even better, I am inviting everyone to attend tomorrow's session with the principal organs of the ICC and the Commonwealth Women Parliamentarians. During the session with the ICC President, the Deputy Prosecutor of the ICC, as well as the Special Advisor on Gender to the Prosecutor, we will hear first-hand information on the main achievements and challenges for the ICC in this year, the status of investigations and prosecutions before the ICC, sexual and gender-based violence in the framework of OTP investigations. And I would like to end today with one extremely important point for PDA as an organization and for me at the personal level. I know that my colleagues in PDA also share this view. I would wish to take this opportunity to pay a tribute to Mr. Felipe Michelini, an extraordinary human rights advocate and leader of Uruguay and within the international community, who has passed away this year. Mr. Michelini has been a long-standing member of PDA and an incredible, generous and enlightened scholar and politician. It was him who had the initial idea to create the CAP-ICC in early 2002. In the month that led to the entry into force of the Rome Statute, together with a Dutch parliamentarian named Gerrit van Oven, Philippe became a PDA board member and addresses several sessions of our CAP-ICC in Ottawa, Tokyo, Kampala, Rome, and Rabat. It was a great sorrow that for the first time we cannot welcome him here and benefit from his insightful contribution. And as I said, Felipe was also a very good friend. He have always been on the step for those who need the law and the protection from the legislative process. And we will always, as members of PDA, remember his work against impunity. And by this word, I will end my speech, and I look forward to meeting you again tomorrow at 2:00 Central European Time. And thank you very much for your attention. Good evening.
Thank you so much, Margaretha Sederveld, for your inspiring and also moving words. As host of the first day, I would like to conclude this webinar and hope to see all the participants tomorrow again, exactly at 2 p.m. Central European Time. Thank you so much, Margaretha, and see you all tomorrow. Bye-bye.
See you. Bye-bye.